typically adjourned to 2nd of July. And on 3rd of, it was not listed, and on 3rd of July, I have made mention before this one. Not come.
Second appeal for fresh admission. My lord, second appeal for hearing.
कोई year
My lord, 2000.
जानना था मेंशन कर दियो मैं मोटा be ready and then make a mention before the court. Yes.
Given a memo, my lord, of the year to
Ajit.
yes, my lord. That is Anganwadi matter. Let it be registered as present.
I beg your pardon to mention, your lordship, this is RSA number 207 of 2016.
No.
The matter was specifically adjourned to 25.
देखिए
Published.
item number 1 election petition.
Respondent is the elected candidate from 12. Certified.
Is it in order?
My lord?
Is there any defect pointed out?
No, my lord.
Okay, so then it has to be admitted today.
My lord.
So what is the matter? Please tell me.
My lord,
I am new to this branch of law, so you'll have to assist me.
no, my lord.
No, actually, I'm new to this law.
Respondent is the elected candidate from 12 Raulkela Assembly constituency to Odisha State Legislative.
What is the meaning of 12 Raulkela Assembly Constitution?
My lord, that is the constituency.
Karnataka se.
Again.
Tapare?
But while respondent filed their nomination paper, he has filed 4 sets of nomination paper. And out of 4 sets, my lord, serial number 33.
Representation of People Act, Representation of People Act, People's Act of Accord. Yes.
Serial number 33 affidavit was accepted, my lord, by the returning officer after scrutiny. My lord, in that nomination affidavit, the respondent suppressed his property details and has given wrong information in regards to the property. My lord, may kindly have a glance to the page 20
of the documents that you have filed
26,
today.
which I have filed today, my lord.
Page 26.
Page 26, my lord. Column B. Detail of,
And these documents be taken into consideration when you have not filed them along with
my
the
lord,
claim.
I have downloaded from the public domain.
I don't know, you tell me. This is to be dealt with as a civil suit, isn't it?
My lord, my lord, my lord.
So the documents that have not been filed along with the plaint, you must have filed, there must be some endorsement saying that these are the documents you are relying upon.
Yes, yes, my lord. With the plaint, I have stated so. In page page 26, my lord. Page 26 of my brief.
List of documents related upon nomination affidavits of respondent downloaded from so and so, but you have not given the list. This is the those copies.
Yes, ma'am.
You should have given a list actually.
But at that time, certified copy, I cannot.
You should have given a list of documents that you are relying upon. So how will the respondent know which affidavits are you relying upon? So these have to be included in the plaint. Yes. Yes.
Yes, my lord. Page 26 of my list of document today, which I have filed.
Yes.
My lord, in column B, serial I, he has stated that agricultural land location Mauja Sankilo Khata number 412 plot number 198. In the next table, he has stated area is 0.435. Whereas, my lord, in the certified copy which I have given at page 6, my lord, sorry, my lord, page 5, my lord.
Yes. Page 6 nahi thi wo.
Page 6 is the area. Yes, ma'am. Page 6 is the area and
there are two plots.
My lord,
he is referring to only plot number 4, plot number 198.
198.
198 is not there here.
255, my lord. Achha na? Page 6.
Oh, acha. Chakka bhukta hoiଥିବା plot.
Again.
198 Hura Tala.
Yes.
It is 255.
He has given wrong information in regards to this plot. And the second thing is he has suppressed in regards to plot 260. And also he has suppressed, my lord, the two ROR which I have filed, page 1 to page 4. Though his name is there.
I think you'll have to file a petition to take these documents on record.
Well, I will file an IA, separate IA.
You file an IA, then I will
Yes,
take
yes.
it. File an IA. You have to, relate these documents to the list of documents relied upon.
My
Only it
lord.
can be taken on record and thereafter it can be admitted, question of admission will be considered.
My lord.
So what is your basic ground of challenge?
Basic ground of challenge is, my lord, suppressing, respondent suppressing the property details and suppress the criminal cases pending against the respective lower court, my lord.
So that comes under that misconduct under
125A of the Representation of People's Act, my lord.
125A.
Yes. And 125A read with section 100 of People Representation Act, which provides grounds for decree. May I read, my lord?
125A though?
Yes, my lord.
Yes. Yes.
Penalty for filing false affidavit. A candidate who himself or through his proposer with intent to be elected in an election fails to furnish information relating to subsection 1 of section 33A
Yes.
or gives false information which he knows or has reason to believe to be false or conceals any information in his nomination paper delivered under subsection 1 of section 33 or his affidavit which is required to be delivered under subsection 2 of section 33A as the case may be, shall notwithstanding anything contained in any other law for the timing in force be punishable with imprisonment for a term which may extend to 6 months or with fine or with both.
Now this is included in the list of grounds
Yes, ma'am.
under which you can declare an election void.
Yes,
Under section 100.
100.
Let us come to section 100.
My lord. May I read, my lord?
Yes, please.
Grounds for declaring election to be void.
Your prayer is to declare this as void.
Yes, yes, ma'am.
Yes.
Subject to the provisions of subsection 2, if the High Court is of opinion that,
Which one is relevant?
my lord, relevant is column Roman IV.
By the non-compliance.
By any non-compliance with the provisions of the Constitution or of this Act or of any rules or orders made under this Act, the High Court shall declare the election of the returned candidate to be void.
All right. So we'll call this tomorrow.
My lord.
Learned counsel for the petitioner wants to file an IA. Let's this matter tomorrow. Along with the IA, if filed in course of the day.
Yes, my lord.
Item number 2. May I please, Your Lordship. Sir, item number 2 on behalf of Mr. Pitambar Acharya, Your Lordship. May I pray that this matter be passed over, Your Lordship.
That's all.
At 2 p.m. May I pray, Your Lordship, at 2 p.m.
2 p.m. He has joined today probably.
Yes, Your Lord.
All right. We'll take it up. The problem
Okay,
is
Your Lordship.
this is against the same candidate, same route clerk.
Same candidate, but he is the election petitioner, Your Lordship.
No,
Yes.
and this person is also, this Rajkumar Yadav was also a candidate,
Yes, yes, my lord.
and Mr. Dilip Kumar Rai is also
Yes, yes.
against the winning candidate.
Winning candidate.
Since I think both need to be heard together, isn't it? I think there is we'll admit, if at all we will admit separately, we'll
Okay.
issue summons. At the time of hearing, we may club it.
Okay.
Let us see.
2 p.m. Your Lordship.
Yes, 2 p.m. You file your
Yes.
Yes,
petition
ma'am.
tomorrow.
Yes.
But in course of the day, so that it can be tagged to the case record.
Yes, ma'am.
Tomorrow or day after? Day after.
Tomorrow I will.
No, day after. No, you can file it.
Yes, ma'am.
All right, tomorrow. Yes. Item number 3.
My lord, I'm for the wife.
Yeah.
Filing the petition and transfer. I want to transfer this petition from Bhubaneswar to Hindol.
Also to Indore. On what ground?
ରାତିରେ ବାହାଘର ହେଇଥିଲା ଯେମିତି ପୁଣି ସେ ତାର ଛାଡି ଦେଇକି ପଳେଇଛି ଆଉ ଆସୁନି।
ଟ୍ରାନ୍ସଫର କାହିଁ କରିବାକୁ ଚାହୁଁଛନ୍ତି କେସ୍ ଟା?
ମୁଁ ସେଇଠି ହିନ୍ଦୋଳରେ ରହୁଛି, ସେଇଠି ବି କେସ୍ ଆହୁରି ଫାଇଲ କରିଛି, ଡିବି କେସ୍ ଫାଇଲ କରିଛି ସେଠି।
Issue notice to the opposite party by speed post, fixing a short returnable date, requisites to be filed by tomorrow. Peremptorily, let's this matter.
20th August.
20th August, September.
2nd September.
2nd September. Adjournment, huh? Adjournment.
Stay. I stay.
Adjournment.
Okay.
Hey, shala.
Item number 4.
Item number 4.
May I please your lordship?
In item 4, your lordship wanted to know the up-to-date position. The up-to-date position is on health ground. The person, the lady who was appointed as in 2010, after being selected by the Mahila Sabha, he resigned on the ground of health. And because of the code of conduct, no fresh selection had been held. So this is the.
No, but the order is something different, I think.
My lord.
She claims that her name was recommended for engagement as Anganwadi helper.
Yes. This
Since no action was taken, she approached this court in the earlier writ application.
Exactly, my lord.
That was here the direction was to the CTP of Purushottam to complete the process of selection. That's all.
Hon'Ble.
That's it. So then in the selection process, another person was engaged. So on the allegation of the petitioner, that said person, that selected person was removed, disengaged. And now
That
she was
post is
engaged
vacant.
against that vacancy.
And your
That is
lordship
what
wanted to know.
that is the result of the
whether
conclusion
that
of selection process as directed earlier by this court and also particulars of the person who was engaged in such selection.
My lord.
You have to give your written, you have to obtain written instructions, Mr. Das.
I
You
get.
Yes.
have to file a counter here.
This was of June. This instruction is of June 2024.
This order was also passed on 24th June.
Sir.
So probably thereafter you have not obtained instruction. You have to obtain instruction.
This is the up-to-date instruction that was given.
Up to what is the date?
The date is 27th of June.
Then it must, we can treat it as up to date, but it doesn't answer the query.
Yes, as your lordship had directed.
Learned State Council has obtained instructions, but the same does not answer the specific query posed by this court in the previous order. As such, Learned State Council is directed to obtain specific written instructions with regard to the query posed by this court, and if so desired, may also file an affidavit. List this matter. 12th August. 12th August. Yes. It's order to continue. Subject to result is you.
I get it.
Anyway, it's
I
order
get
to continue.
Oh, bless me.
Item 5. Yes.
May I please your lordship? The petitioners were engaged as post-literacy program worker under the post-literary program worker scheme, my lord. Well, the scheme was abolished in the year 2006, my lord. Thereafter, the petitioner has made a representation to the authority to re-engage them or to adjust them in any group B or group C or group D post, my lord. Lordship, may I kindly have a glance at Annex 5 for a moment, page 31.
No, you are working as?
What was working as? My lord, I have already returned after abolition of the scheme, my lord. Working as the post-literacy program worker in different primary and upper primary school, my lord. Under the district education officer of Cuttack, my lord. Thereafter, my lord, after abolition of the scheme, my lord, I have approached the authority. Thereafter, lordship, kindly have a glance at Annex 5, my lord. Annex 5, page 31. My lord, this is the letter of the district education officer to the director secondary education Odisha Bhubaneswar, my lord.
देखा जाऊंगी बिल्कुल. I have to say that the PLP worker Banki has submitted to present.
But this is the latest order on 15/3/2024. My lord, thereafter there has been no communication. Lordship, only my prayer is that I have made a representation under Annex 6, my lord. Let it be considered keeping in view this, my lord, Annex 5. My lord,
मोर आ गोटे डिस्पोजल मो डिस्पोजल लिस्ट मोर गोटे ऐड हो
no, my lord, actually this will help the purpose because
किछि व्हाट राइट डू यू हैव आपन को स्कीम बंद हेगला
Yes, ma'am.
जे हमको आगे पेंशन पोस्ट गोटे एंगेज कर दियो वी हैव अप्रोच देम विथड्रॉ करन मु लिबर्टी दे देबी विथड्रॉ करन विथ लिबर्टी
my lord withdraw कले से और किछि
कहबेनी
से करिवेन.
यस इट्स नाइस
Only my representation to because my lord, erstwhile Gana Shikyok, my lord, erstwhile education volunteer.
neither you are a person aggrieved nor there any vested right is there in your favor.
No, I don't have any vested right. But my lord, erstwhile EGS, my lord, education volunteer who had disengaged after abolition of the scheme, my lord, they were re-engaged as Gana Shikyok.
Disposal of the aforesaid let's see what the instruction happened. Yes.
I'm sorry, I have not been supplied with the copy.
Copy to the
Sir, copy ଅଛି। Sir,
as many as 51 petitioners. The petitioners who are 51 in number, who are working as post literacy program workers against Group D post. In the Cuttack Education District. The literacy program was abolished subsequently. Stop. As a result, the petitioners were thrown out of employment. By a letter dated 15/3/2024, the Additional District Education Officer Cuttack sought for the disengaged employees thereafter requested for consideration of their case for absorption against an equivalent Group D post. By a letter dated 15/3/2024, the Additional District Education Officer Cuttack sought for instructions from the Director Secondary Education regarding engagement of such retrenched or disengaged PLP workers as peon under DEO Cuttack. The petitioners have also submitted a representation addressed to the Director Secondary Education on 10/11/2023. The limited grievance of the petitioner is that said representation has not been disposed of as yet. Having regard to the innocuous prayer of the petitioners, without expressing any opinion on the merits of the claim of the petitioners, the writ application is disposed of, directing the Director Secondary Education Orissa to consider and dispose of the representation dated 10/11/2023 submitted by the petitioners, if not already disposed of in the meantime, by passing a reasoned order within 2 months from the date of production of certified copy of this order by the petitioners. मोर गोटे डिस्पोजल हे गेला नहीं
grateful mail. I do not take.
May I pray, my lord, the termination of an Anganwadi worker with annexed 11 at page 75 or order
Collector.
13/6/2024 is subject matter.
Anganwadi worker or helper?
Anganwadi worker. But before I go to the impugned order,
Maybe an
permit me just
appellable
to, yes, I'll come to that also. Lordship, allow me just 2 minutes.
Yes.
Lordship, I have the date chatting also. Kindly have that. At flags. Highly like it.
Oh,
In 2007, in 2009, there was an advertisement.
There is no date chart here.
My lord, date chart I have submitted along with the synopsis and date chart.
Oh,
Yes, say date chart.
yes.
An advertisement for Anganwadi worker is issued in 2009. Then I applied. In 2010, I got selected. 19/1/2000. Then that selection was subject matter of a challenge in an appeal filed by another candidate, unsuccessful candidate Anita Parida, on the ground that my disability certificate is fake. The on 15/9/2010, the certificate was verified and found to be genuine. Then, my lord, the appellate authority passed the order holding that the certificate is genuine. Against that, a writ application has been filed. I'm sorry, my lord, that is not, the date has not been mentioned there. Against that, a writ application has been filed in the year 2011. That your lordship find out at page 70, which is still pending, challenging that order. Now, this is still pending. Now, after so many years, after 10 years, now a sponsored litigation, pardon me for using that word, filed here before this honorable court in CRLMP, saying that we have filed, made some representation to police. Police is not considering, therefore the CRLMP. Now, in that CRLMP, this honorable court say, without expressing any opinion, you can approach CBCID. So now the CBCID entered into the fray. Now, lordship kindly see the FIR. That's also quite interesting. FIR I have annexed. The CBCID after that at page 78. It starts from 76, annex 12.
On the allegation that I produced a fake eligibility certificate.
That's the allegation, my lord. Kindly see the paragraph 2, last 4 line. In this regard, Inspector Behera obtained the reply from CDM and PHO Jagatsinghpur by letter number so and so, which reveals that disability certificate was issued in favor of Anjana Swami on 16/8/2017, by registration number of the disability certificate. So it is again in 2021 also the CDM say yes, this certificate is issued in my favor. Now, my lord, at page 81, this similar situation. Page 81, basing on the replies received, I am reading, my lord, as your lordship.
Yes.
That it is undisputed that Anjana Swami was a person with physical disability. Then other observation. Now, this is the report considered by the SDO, subdivision officer. That's I am taking the allegation. Past show cause is issued at page 71. Kindly mark, my lord, the date. On 4th of March 2024. This clearly again taking the entire allegations in the FIR. This is no charge sheet has been filed. I am on bail and this is continuing, and every authority has stated that this certificate issued by the CDM is genuine. Now, my lord, this is the show cause receipt. I gave a detailed reply. The next page. Then, my lord, the second show cause issued. On 7th of June. Then I made my reply. The next page, my lord. And this is the order. Now, kindly, my lord, read this in the order. I am drawing your lordship's attention to the second paragraph. Whereas the investigating officer reporter dated 29th March 2020 and the report of public health officer Jagatsinghpur filed letter number 611 dated 3/4/2024 established that, my lord, this is the document they received in April. The show cause was issued in March. Even what is that document? Nobody never produced to me, never shared with me. No allegation even contained in the show cause notice with regard to that. Least to speak about sharing. Now, my lord, these circumstances with this, this is the reason, my lord, for which I have been disengaged.
Take notice. Take notice.
And in the meantime, they are proceeding to.
You'll accept notice for all?
Yes.
The Airdas Learned AG accepts notice for all the opposite parties. Let a counter affidavit be filed within 2 weeks or within 3 weeks. List this matter. 3 weeks for it. 2nd September. Okay, 2nd September. Interlocutory application कौन होगा?
Again?
Interlocutory application कौन?
Interlocutory मैं आउट फाइल करছি से एडवर्टाइज कर देनी मो पोस्ट तक तो सेटा not fill up now 9292 IA number.
All right. IA 9292 of 2024.
Advertisement dated number 731 dated 10th of July 2020.
The post of Anganwadi worker of putting to Anganwadi Center in the district of Jagatsinghpur shall not be filled up without leave of this court pursuant to advertisement number 731 dated 10/7/2024 till the next date.
Item 7.
May please the lords. My lord, Annexure 1, the advertisement issued for filling of various posts of Anganwadi centers, and the center in question is Muslim Sahi. This was issued in 2017. Along with me, other candidates applied. On the date of scrutiny, that at page 12, 7th June 2017, documents were supposed to be verified. This could not be done, and one person was appointed. This was brought before this Honorable Court, and this Honorable Court granted liberty for appeal. In the appeal, the appointment of the person concerned was set aside on the ground that no verification of document of each candidate done. It was done singularly. Thereafter, the said order was challenged the person who was appointed by the Annexure 2, my lord. This Honorable Court in a read petition here in the month of February 2024, page 16, my lord, confirmed the order of the appellate authority that the process was undertaken, singularly verification was done, so they quashed. Now, instead of carrying with the advertisement and furthermore, they are issuing fresh notification. That is the
Fresh notification, ma'am?
fresh notification.
Fresh advertisement.
Fresh advertisement.
Scanning করছি দেখলো সব
And in fact,
বড় উল্টা
I have got improvised documents subject to scan ହେଇଗଲା ପରେ ବି ଆଉ ଟିକେ black ହେଇଯାଉଛି.
Hey, that's it. So 3. 4/5/7/2024.
My lord. In February, this Honorable Court said,
All right. Take notice.
and the center is Goleipur Muslim Sahi. That is page 23.
The Airdas Learned AG accept notice for all the opposite parties. Let a counter affidavit be filed within 3 weeks. List this matter on
9th September.
9th September. आइए.
The center in question is Goleipur Muslim Sahi.
The process of selection of Anganwadi worker in respect of Goleipur Muslim Sahi Anganwadi Center shall remain stayed pursuant to advertisement dated 5/7/2024 shall remain stayed till the next day.
Great.
Item number 8.
Please, your lordship. On behalf of Mr. kindly taking the matter after 10 days because he wants some instruction from the client.
My lord, may I be permitted? On the last occasion, my lord, the petitioner had filed one additional affidavit. And disputing the fact that, my lord, as per the instruction, I submitted the documents but not supported with an affidavit. So I have already filed an additional affidavit, my lord. I'm serving a hard copy of this and serving a copy also to the petitioner.
Yes. This additional affidavit was, so you are filing reply to this additional
Yes,
affidavit? Learned AG files again an additional affidavit on behalf of opposite party number 4 purporting to be in reply to the additional affidavit filed by the petitioner on
That is scanned on 9th May.
shut up. On 5/5/2024 can be kept on record. Copy of the additional affidavit has been served on counsel for the petitioner in court. List this matter
5th August.
on 5th August.
Item number 9.
The it goes 6 of 2020, 6 of 7.
Is that to this case, actually, I filed a IA for modification of that part of order. But because the case record is attached to this case, it could not be listed in the other one, though it was directed to list on Friday.
ଆଚ୍ଛା
So may I pray let it be common next week?
ମୁଁ ବୁଝିପାରିବି ସେ ଆର ମ୍ୟାଟରଟା ମାନେ
ଏଫଓ ଟା ଗୋଟେ ଟ୍ୟାଗ ହେଇନି guys?
ହଁ ହଁ ହଁ
ସେ ଏଫଓ ରେ ଗୋଟେ ମଡିଫିକେସନ ସେ କହିଥିଲେ ଯେ full compliance ହେଇଛି ବୋଲି କହିଥିଲେ ବୋଲି the objection was raised by this my friend.
so we,
So I filed a modification.
so this will be listed next week
ଏଇଟା ନେକ୍ସଟ ୱିକ୍ ହେଇଯାଉ ଟିକେ ରିଲିଜ କରିଦଉ
ସେଟା release ହେଲା?
ଆଜ୍ଞା ନ ଲିଷ୍ଟ
the case record of FAO number 6 of 2007
ମାଇଲ
2017
6 of 2007
6 of 2007
କେତେ
ଆମର ଅଛି କୋନଟା
No,
Oh,
2000.
6 of 2017 ହେଇଯାଇଛି ରେ ତମେ ଭୁଲ ଫାଇଲ ନେଇ ଆସିଛ ଆଚ୍ଛା ହଉ FAO number 6 of the case record of FAO number 6 of 2017 be I mean delisted ହେଲା ଆଉ ଆରଟା ତ ଆସିନି ଆଉ କଣ କରିବି
ସେଟା ଅର୍ଡରଟା ଅଛି ବୋଲି ସେଟା କଣ ରିଲିଜ ହେଇପାରୁନି ଫାଇଲଟା ଯାଉନି
ଆଚ୍ଛା
ସେ ଅର୍ଡରଟା ଉଠା ଉଠି ଫିଲ୍ ଆଇଛି
further FAO number 6 of 2007 be also delisted to be placed before the assigned bench. List this matter
ନେକ୍ସଟ ୱିକ୍
next week.
ଆଜ୍ଞା
Next week ହବ ଆମର ଦେଖିଲ
ହଁ ଏଇଟା ଛୋଟ ପଏଣ୍ଟ ପାଇଁ ରହିଛି
ନା ନା ସେଇ ରେଫରେନ୍ସ ପାଇଁ ତ ନ କଲେ ହବ ନା 2007 ଟା ତ ଅର୍ଡର ହେଇଛି ନା
ହଁ ସେଇଟା ଆସିଛି
ଓ ଆସିଛି
ହଁ
ଏଟା ଭୁଲ ଲେଖା ହେଇଛି ଆଚ୍ଛା ଆଚ୍ଛା ତାହେଲେ ସେଇ 7 ଅର୍ଡର କରିଦିଅନ୍ତୁ
Order
Be
status
delisted.
ଅଛି 6 of 2007.
ନାଇଁ ସେଟା ବୋଧେ ଲେଖିଲା ବେଳକୁ ଲିଷ୍ଟରେ ଭୁଲ ଲେଖି ଦେଇଛନ୍ତି
ଆମେ ଚେକ୍ କରିଥିଲୁ ଫାଇଲଟା ଆସିଛି ଆପଣ କୋଉଠୁ
ଆସିଛି ତ ଆସିଛି ତ
ସେଟା ରିଲିଜ ହେଇଗଲା ନେକ୍ସଟ ୱିକ୍
ନେକ୍ସଟ ୱିକ୍ ପରା
Item number 10.
Item 10, my lord, on behalf of Ms. Jenna, pass over, my lord, after lunch.
after recess ନାଇଁ pass over yes
Because she has some personal difficulty.
you seek adjournment
No, pass
after
over,
lunch I have personal difficulty
pass over, my lord.
pass over ତ କରୁଛେ pass over ପୁଣି after lunch କଣ
Tomorrow, my lord.
ନା pass over ନା କଣ
Item number 11.
May I please, your lordship. Here, my lord, I am challenging the order passed by the ADM Kendrapada in Anganwadi appeal number 2/20, set aside the appointment of the petitioner as an Anganwadi worker. The fact of case is that the petitioner was initially appointed as an Anganwadi helper, my lord. In the year 2001, my lord. And for Anganwadi center, and thereafter, one Gitanjali Janna was appointed as a Anganwadi worker, my lord. He died. Thereafter, I selected as a Anganwadi worker in the year
no you
2018
you were appointed as 7/5/2001 as Anganwadi helper
helper,
of that Danapur
Danpur Anganwadi center.
so
In the year 2018-17, one Anganwadi worker died,
there was a casual vacancy
casual vacancy. And thereafter, the selection committee selected the petitioner as a Anganwadi worker in the year 2018, my lord.
all right
In the year 2020, my lord, the appeal was filed by the two private opposite parties on the ground that no selection procedure was done. So the appointment of the petitioner as a Anganwadi worker is illegal and void. And accordingly, the ADM also set aside my appointment. My humble submission before your lordships that, my lord, there is a two provision for selection of Anganwadi worker. One is for inviting application from the candidate, and another one is if a Anganwadi worker, a helper is there, and he has doing his service more than 5 years, then he will selected as a Anganwadi worker, my lord. If your lordships, with permission, my lord, the guideline provided in the year 2007, my lord. Paragraph 3, my lord. With lordship's permission, can I place? My lord. application for selection of volunteers to work as Anganwadi workers will be invited for each village or Anganwadi center area from women residing in the said village or Anganwadi center area. The applicant will be female candidate.
Just a moment. Yes, please.
The applicant will be female candidate in the age of group of 18 to 42 years on the first.
Wait, it only says that it means that she will be given a preference, she will be given preference, but without selection, how hogi?
My lord, there is no guideline for preferential in respect of.
No, not a question of preference. You see,
My lord, in the
see the language. You see the language. The shalta lekha hi jaichi. It has not been very happily worded. Page kete?
My lord, the page 29. Running page 30. Start from 29, running page 30. Page, sorry, my lord, paragraph 4.
Anganwadi helper and organizer, if having the requisite qualification and are found to be suitable,
My lord,
shall be selected.
my lord. As an Anganwadi worker, my lord.
So, how will their suitability be known?
My lord, if he will be, if he will work as an Anganwadi helper.
No, set eligibility. Suitability is something different. Suitability is always in comparison with other candidates. It's a relative thing. Suitability means it has provided she is suitable from among other candidates, she is suitable, so she will be given preference. Anyway, so but here there's a who's for the private opposite party? You are appearing.
Yes,
What is your locus standi?
because I am the inhabitants of the ward number 6 and 7.
Very
Number
good.
one.
Very good.
Where-
You were appointed in
where-
2018.
18 where-
You woke up from your long slumber in 2020.
After death of the Gitanjali, the Anganwadi worker, I several times approached, that has been pleaded. I several times approached to the concerned CDPO.
What is the effect of multiple representations?
No, only I approached.
All right, all those multiple approaches. Let us not use the word representation. Let us use your word approaches.
But I am the ward number, I am an aspirant of that post.
No, you have no locus standi. You have no locus. Satisfy the court about your locus standi. Then I will consider. What stand have you taken in your counter affidavit?
Kindly have a glance.
Counter affidavit has not been filed.
4 and 5 ki file question?
4 and 5 I have filed.
You are
Yes.
Private.
private dion kimti. Pori sandhya hai na 5 Mamata Muhima. Who had filed the appeal?
I have filed appeal.
I mane ki apan to dijon.
The two persons have filed the appeal before the. I filed the firstly before this honorable court, and pursuant to the direction of this honorable court, we preferred appeal.
Yes.
4 and 5 preferred appeal before the ADM, and ADM passed the impugned order. At that time, they have not hesitated this thing, and now the annexure F. I have filed annexure F, that is the document. I have filed those two persons are the inhabitant of the ward numbers 6 and 7. The persons who applied the post, he is the ward numbers 8. He is not the clause. He is not the ward number 6 and 7. Now the Anganwadi center has been open for ward number 6 and 7. Ward number 8 is different. There was one center 6 and 7 and 8. When new Anganwadi center at in that case, in that center, he was the helper and one Gitanjali Janna was the worker, Anganwadi worker. But so far as 6 and 7 is concerned, she was promoted to the ward number 6 and 7, where he the present petitioner is not the inhabitant of the which violates the provisions of guideline, that is Guideline 25/2007, which my learned friends saw.
Where
That
have you said in your counter that you had approached, she was appointed in 2000?
yes, I have mentioned,
Let us see your counter.
Here with lordship permission, my lord. Initially, it was Danpur Anganwadi Center, and subsequently it was divided. There is Anganwadi.
Yeah, let us see.
Paragraph 9 of my counter.
Yes.
These opposite who are the inhabitants of ward number 6 were aspirant to apply for the post of Anganwadi worker for Danpur Anganwadi Center, when the opposite party number 3 shall give notice for fill up the casual vacancy of Anganwadi worker for Danpur Anganwadi Center, for they proceeded to the office of the opposite party number 3 and inquired when it shall be notified in the notice board, but the opposite party expressed that the petitioner has been appointed as an Anganwadi worker for Danpur Anganwadi Center. Thereafter, these opposite through RTI Act sought for information and came to know that the opposite party number 3 illegally appointed the petitioner as an Anganwadi worker at Danpur Anganwadi Center.
Where is that? Where is that RTI application or the information submitted furnished to you? Where is that?
RTI application
Counter affidavit dinner.
that has not been disputed. So far as when office,
Question of disputing.
Huh.
It's a question of first you have to satisfy the court about your locus standard.
yes, I will see some over. And another aspect, I will draw your kind attention. What courts available? Paragraph 85 of the guideline, page 85. The Durgesh Nandin Sahu, what course is available?
Well, that goes without saying. That is what I had pointed out in the beginning. See, that's all right. There is no dispute that she was working as a Anganwadi helper.
Definitely.
That is not disputed.
That is not disputed so far as one number.
Whatever, at that point of time.
Huh.
We will have to go back to 2018. We are not concerned with now.
Yes.
Concerned with what is the state of affairs now. But in 2018, whatever was the prevailing situation. So she was engaged. Rightly, wrongly, she was engaged. It was never challenged. In 2 years later, you come forward to challenge.
Definitely, but I approached. This is my.
Where is that? You have approached. That is what I'm asking you. You say you had submitted some application. You were under the RTI Act. You were furnished with some information. Where is that?
I will find.
All right. In course of hearing, a learned counsel for the private opposite parties refers to paragraph 9 of the counter filed by them, which indicates that they had sought for some information through the RTI Act and came to know that the present petitioner had been appointed as Anganwadi worker of the center. So this court would like to peruse the RTI application so submitted and the information received. Does this matter? No, learned counsel for the private opposite parties is directed to produce the same. Does this matter?
Yeah. 20th August.
On 20th August.
Item number 12. I may be permitted on behalf of Mr. A.S. Mahapatra.
Last time they have to file the amendment because he already retired the prayer for promotion to the post of assistant professor does not arrive. If at all benefit can be given, your lordship dispose of the direction in light of the circular available Annex 3. If she can be given the benefit, that is to consider.
Only benefits to be considered because she has been died and on the death of the original lead petition,
He has been substituted.
Her husband has been substituted. Before your lordship, now in the present writ application, her husband has been substituted.
So what is the prayer?
Prayer, your lordship.
You have amended your prayer.
No, I have not.
So in the absence of any So the original prayer cannot be considered
Only that.
to give appointment to the petitioner in the post of assistant professor. by
Assistant
consider-
professor, the junior lecturer, she has appointed
So
and considered.
that prayer is no longer available to be considered.
That.
Because the
My,
person-
what in the REIT application, original REIT application, my retirement at the verge of 60 has been challenged before your lordship. That is as per the UGC rules, and as per the assistant profession, that is 65.
Yes.
My retirement at the age of 60 has been challenged before.
True.
your
But thing is that this prayer now cannot be considered, obviously.
only prayer,
Firstly, you have retired, and secondly, you have died.
yes,
Isn't it?
both the part.
Well, they have died.
Yes, ma'am. Obliged, my lord, I will file only amending the prayer.
There can ଆପଣ ତାକୁ କିଛି ଆଉ କରିହବନି ଏଥିରେ କଣ କରିବ?
It's a good case, but I am going through that Mamata Manti case and other case of Kerala High Court. Probably it's a good case.
Yeah, maybe, but so you approach the
On several approaches, I have in my REIT application during my service period also, before retirement. I have also, because why I am saying that? My post have been approved. Had been approved during my service period.
No, but here you are claiming promotion. In the original writ petitioner wanted promotion
Yes,
to the post of or rather
but
appointment.
benefits are there. But benefits are there because I have represented on several times during my job period.
No.
My job period for the post of
Promotion cannot be a matter of right. Cannot
No.
be. Then
other benefits are there.
what benefits?
Service benefit?
Of the higher scale. Yes.
Yes.
Provided you were promoted.
That if my promotion is considered, then
Again, promotion. If this court comes to a finding that your husband was or your wife
My
was
wife.
wrongly deprived of the
Deprived.
promotional avenue or the promotional post, then maybe something can be done.
that
But
my
that is also no longer available. That is also no longer available. In view of two things. First, death. Second is retirement and second death.
What? Sorry. How I will verify and if possible, I will file the amendment. Prayer person, not other person to be required. Because at the husband has been substituted prayer person.
It is entirely contingent upon promotion.
Promotion, that's. If findings will be come out that my promotion is required and my promotion was not promoting me to the post of assistant professor is wrong,
Very difficult.
then
It will be very difficult.
because why I am saying the Kerala High Court decision
This becomes
somehow,
no. This becomes speculative. This becomes speculative.
yes,
It
On
is
the death.
entirely contingent. Yes.
on the
obviously.
death.
Had
Not
you,
on
had
the
you been
death,
alive?
but on the death,
Had you been alive? Yes.
yes. Because death is after 2 years.
All right. Learned counsel for the petitioner wants to file an application for amendment of the prayer made in the writ application. Let's this matter go to week for 5th August. 5th August.
Obliged.
Application for amendment.
He is not coming.
I have application for
Direct.
amendment if any be filed in the meantime. The name of the CORAM, learned counsel applying for the
Central government.
yes.
Central government, opposite party.
Central government be reflected in the cause list.
Obliged.
Item 13.
13, a rejoinder affidavit has been filed on 15/7.
Yes.
I have received the copy. There an assertion has been made in paragraph 3 that instruction I have to obtain from the authority. Paragraph 3 in the rejoinder, after he has said,
ମୁଁ ଟିକେ କ୍ଲାରିଫାଇ କରୁଛି ବଟ୍ ଆନେକ୍ସ ଯୋଉ ରିଜେଣ୍ଡରରେ ମୁଁ ଆଇ ୱାଜ ଆପଏଣ୍ଟେଡ୍ ବାଇ ଦି ଭିଲେଜ ଏଜୁକେସନ କମିଟି ଏନଗେଜଡ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଟିକେ କ୍ଲାରିଫିକେସନ କଲେ ୱାନ୍ ଅଫ୍ ଦ କଲେକ୍ଟର ଖୋର୍ଦ୍ଧା ସର୍ଟ ଫର କ୍ଲାରିଫିକେସନ ଫ୍ରମ ଦ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଇନକ୍ଲୁଡିଂ ଅଦର କଲେକ୍ଟର୍ସ ହ୍ୱାଟ ଉଡ୍ ଦ ମୋଡ୍ ଅଫ୍ ଦ ସିଲେକ୍ସନ କ୍ରାଇଟେରିଆ ଫର ରିହାବିଲିଟେସନ ଆଣ୍ଡ ଏନଗେଜମେଣ୍ଟ ଅଫ୍ ଦ ଏଜୁକେସନ ଭଲେଣ୍ଟିୟର ଆନେକ୍ସ 15 ମାନେ 28/8 ରେ ପେଜ 30
But he wants to obtain instruction.
ମୁଁ ସେଇଥିରେ ମାନେ ମୋର ଟିକେ ବି ସବ୍ କାଇଣ୍ଡ ଅଫ୍ ରେସ୍ପନ୍ସିବିଲିଟି ଏଇଥିରେ ଲେଖା ହେଲା ଏଜ୍ ରିଗାର୍ଡସ୍ କ୍ଲାରିଫିକେସନ ସଟ୍ ବାଇ ଦ କଲେକ୍ଟର ଆଣ୍ଡ ସିଇଓ ଜିଲ୍ଲା ପରିଷଦ ଖୋର୍ଦ୍ଧା it is further clarified that the education volunteers engaged by the village education committee
as per selection process under the guidelines and approved by the collector and CO Jilla Parishad and approved by the SSA are to be engaged as Gana Shikshaka as per rehabilitation package, whether it is run by the government or other agencies. ଏଇଥିରେ ମାନେ ଭିଲେଜ ଏଜୁକେସନ କମିଟି has the main pivotal role. ମୁଁ ତାଙ୍କ ପାର୍ଟି ଟିକେ କରିବି. So ଯିଏ ବର୍ତ୍ତମାନ ଆମକୁ ସିଲେକ୍ସନ କରିଥିଲେ annexure 3 ରେ page 16 ରେ ଯୋଉ ରେଜଲ୍ୟୁସନ ହେଇଥିଲା ଏବଂ ମୁଁ ରେଗୁଲାରଲି କାମ କରୁଥିଲି ଏବଂ ଭ୍ୟାଲିଡଲି ଏନଗେଜ୍ ସେଇଥିରେ unless the president of the village education committee she unless she comes to the record, so the clarification short for my elder brother may not be ମୁଁ ଟିକେ ତା ପାର୍ଟି କରୁଛି ସେପଟେ ସେ clarification ଆଣ ସେ ବି ଦେଇଛନ୍ତି ମତେ ଏଇଟା ଏବେ.
Counsel for the petitioner wants to file an application to implead the district
village education committee
as a party to the writ application and seeks time on such ground. Learned AGA also seeks time to obtain instructions with regard to the amendments made in paragraph 3 of the rejoinder. List this matter 2 weeks per 12th August.
ମୁଁ ମାନେ ମୁଁ ସେ ମୁଁ ପାର୍ଟି ଏବେ କରିଦଉଛି ମୁଁ ନୋଟିସ ଟା ନେଇଯିବି ଯଦି ଲର୍ଡସିପ allow if lordship allow the addition of parties ମୁଁ ସେଟା at the time of filing writ petition କରିବାର ଥିଲା village education committee is necessary ଏଇ clarification also government
କାଟି ଦିଅନ୍ତୁ ପ୍ରଥମ ପାର୍ଟ ସେନ୍ସଟା କାଟନ୍ତୁ on oral prayer. Learned counsel for the petitioner is permitted to implead the village education committee of
president village education
president village education committee को
ହାଟ ଘର ସାହି EJ center ହାଟ ଘର ସାହି EJ center
EGS center as
OP number 3
as opposite party number 3 in the writ application. Permission is granted. Stop. Necessary corrections to the cost title be made in the court. Stop. Issue notice to the newly added opposite party number 3 by speed post. Fixing a short returnable date. Requisites be filed by tomorrow. List this matter. नहीं तापर लिखूँ तो learned AG 6 selection. तापर लिखूँ तो list this matter on 2nd September.
item 14
2nd September.
bench change August ମାଇଲଟ ଥାର୍ଟି
ପର ମୁହୂର୍ତ୍ତରେ କଣ ହବ ଆପଣ କହିପାରିବେ ମିଷ୍ଟର ମହାନ୍ତି ପର ମୁହୂର୍ତ୍ତରେ କଣ ହବ ଏକ୍ସାକ୍ଟଲି ଆପଣ କହିପାରିବେ
ନାଇଁ ମୋର 100% ଟ୍ରଷ୍ଟ ଯେ ଏଠି
uncertainty life is full of uncertainties.
ଆଜ୍ଞା
चलो yes item 14
case relates to sanction of pension to retired junior assistant of Utkal University. Fact of the case, your lordship will like this.
Who is the other side?
Yes.
Okay.
Unfortunately, my learned senior has served a copy on me, but I would like to have another copy, but this has been misplaced, which is not expected of me.
Application for amendment. Amendment, your lordship, fact is like this. I was initially appointed as consolidated weight basis as a junior assistant in the year 1983. When my
you are appointed as
junior assistant on consolidated wage basis. When my services was not regularized, then I approached this honorable court. This honorable court has allowed my case for regularization. But what happened? Instead of regularizing my service from the date of engagement, I was regularized in the year 2013. I was given appointment in the year 1983, but regularized in the year 2013. Then I was given a retirement in the year 2015. In that case, your lordship, I have filed a contempt case that no services is to be regularized from the date of my engagement. Accordingly, university also regularized my service from the date of my engagement, and all the pay scale was revised and area dues was given. That part has been brought into the notice of this honorable court by way of amendment. That copy I have already sought.
The writ application to incorporate certain developments that have a material bearing that are relevant for this case. The proposed amendment appears to be formal in nature. Sri T.P. Patnaik, Learned Counsel appearing for the university.
T.N. Patnaik.
Sorry, T.N. Patnaik has no serious objection. As such, the amendment application, the IA is allowed. Consolidated
Day after tomorrow.
writ application be filed by day after tomorrow. Sri Patnaik would like to request for some time to obtain instructions. Place this matter on.
Next week, because last year Lordship kindly secured given retirement in the year 2015.
What a reasonable time normally is
5th August.
5th August.
Because I may have to file a counter to the amended
Yes,
part.
you may file, you may file.
I don't know, 15.
Ketra is total 50. Item 15.
Yes, opposite party number 3 is required to file counter.
Opposite party number 3 ki.
Government Higher Education Department.
The case of 42806 of 2020.
On the last occasion, it was said that last chance is granted. Telling me the matter shall be disposed of on available pleadings.
In case of WPC number 42806 of 2023,
Okay.
a counter has already been filed.
So you are adopting it.
Where
So you say that. The Learned State Council.
opposite party number
Learned State Council submits that
No.
the state would adopt
42806.
the counter filed in WPC number 42806 of 2024.
Yes.
Yes.
A copy of the counter.
Let a copy of the counter be served upon Learned Counsel for the petitioner.
So also, my lord, the hard copy also I am going to serve.
Yes. List this matter on 12th August. The rejoinder, if any, be filed in the meantime. Yes.
Item number 16.
Item 16 can be passed over, my lord.
All right. First.
Item number 17.
70. And for the petitioner.
Item 17 is not your matter, Mr. Das.
No, sir.
Item 16 rather.
Lordship, on behalf of Mr. Mahanti, my lordship.
No, item 16 or item 17?
17.
Item 16. Pass over. Item 17.
17. My lordship, in this appeal, second appeal, that is 130 days.
This is the weekly list.
Weekly daily.
Daily weekly.
Yes, yes.
RSS weekly list.
Yes.
Disengagement order is under challenge. Anganwadi worker. Just to avoid multiplicity of litigation, I want to implead the list pendency appointee who has been appointed after my termination as the opposite party. If your lordship permits me,
Yes.
I have also filed my rejoinder by taking advantage of the filing.
Now you are filing an IA.
I am filing in the court today. I have also uploaded it.
Learned Counsel
Again,
for the petitioner
Reach.
files an IA in court
Rejoinder page.
seeking to implead the list pendants appointee as opposite party. So, the IA be registered. Considering the submissions, the IA is allowed. Who is that person?
Name is Shweta Padma. In fact, it was written Shweta Padma, but it is Shweta Padma. From the counter, I got it. And the last page of the counter, my learned friend has filed at page 149 of the running page. Srimati Shweta Padma Mahapatra has been appointed as Anganwadi worker.
Srimati Shweta Padma Mahapatra
As per schedule, I have given that to
is impleaded as opposite party number
8. Yes, she will be 8.
8. Necessary corrections to the cost title be made in the court.
In course. Notice.
Consolidated cost title. Issue notice.
Or better, I will file it by tomorrow.
Consolidated cost title be filed by tomorrow.
Let notice.
Issue notice to the newly added opposite party by speed post. Requisites for which
By tomorrow.
shall be filed by tomorrow. A short returnable date be fixed. Place this matter on
9th September.
9th September.
In August, any date? No.
August dekhila what?
I have filed my rejoinder. Everything has been complete.
27th August.
27th
August.
Your Lordship. I have already, Lordship, take note, I have already filed my rejoinder. There is no rejoinder.
Comes to the petitioner, also files rejoinder in the court.
And only one submission, my lord. The counter has been filed. So he filing, my lord, on 25/7/2022 against which, my lord, he has filed a rejoinder. I'm just solving that.
You are filing what?
The counter to the e-file.
Already on
hard copy to
Learned AGA files physical copy of the counter, which was earlier e-filed.
Yes.
Yes.
I'll file consolidated.
Yes, please file.
I don't know, 18.
Lordships.
Yes.
18 and 19 your lordships can pass over.
18 all the matter. 18, 19 so ekta no. So arrow list. So weekly upon both.
In this item 18, I have already appeared for 5 private opposite parties. And on the first date, I had undertook to appear for the other private opposite parties also. But however, I have not yet received the wakalatnama. I pray for 1 week time so that appearance can be regularized. Thereafter, the matter is otherwise ready for final hearing. Only the appearance is to be regularized.
Yes, Ms. Ratha.
I have no problem, but he was insistent on so many days that the hearing has to happen. So I was very surprised with the submission.
This will be a technical defect if I do not regularize.
Professional reasons.
Lordships. Yes, your lordship. I agree.
You have to understand that.
Yes. But the hammer was there on me was so bad.
I think he's got an interim order just before the Raja Festival. I wonder why this matter is listed to me. This is not in my assignment. But this is
specifically assigned to you.
Yeah.
Because the earlier bench refused
Was not
to hear
fun.
the matter.
Oh, it was concerned. That is why. No, yeah.
We are ready. We are ready with written notes, everything.
All right.
Next
Sri-
week, your lordship.
Sri Aditya Mishra, learned counsel appearing for some of the opposite parties. Requests for a short adjournment on the ground that he would appear for the other opposite parties by filing wakalatnama. Let's this matter next week.
29.
The matter is otherwise ready for hearing. Stop. The other matter is otherwise ready for hearing. As such, let's this matter next week. Wakalatnama for the
29.
refiling the minutes. 29th.
29. Because, first and second, we will not be here.
29th ହେଇଯିବ और
Next week, 29.
हाँ आज तो Monday ଅଛି, if you automatically come on Monday. Is this matter on 29th? Parties are requested to come ready for final disposal.
Item 19.
Item 19. Pass over call.
Item number 20.
20 mile I am the petitioner in this case. I prayed for the withdrawal. And since I have challenged the provisional relationship, so out of the court, there is some discussion.
You file a memo?
Yes.
Land council permitted to withdraw. Yes.
Item 21.
Pass over.
Item 22.
Every lodge. This is a matter regarding reconstitution of Mo School Abhijan Committee at Alumni Association. Last occasion also had and notice was issued, my lord.
And there is an interim order also.
Interim order is there.
Who have not received any instruction from the some more time maybe. This is
Mo School Abhijan Committee.
My lord.
Annex 6 has been introduced.
Learned AGA request for some more time to obtain instructions. List this matter on
12th August.
Huh?
12th August.
12th August. Interim order to continue.
Interim order.
Item number 23. Yes.
My lord, I have item notes 53 and 54. Both the cases has been disposed of by the law and code below.
Both have been disposed of.
Both cases have been disposed of. One I have obtained the certified copy, another of the soft copy of the order one.
Certified copy हमने जो थे certified copy anyway से dispose of कर दो.
Yes, ma'am.
Sri BK Ghodai, Learned Counsel appearing for the opposite party husband, files certified copy of the original certified copy of this has to be on record.
Yes, ma'am.
Will be kept on record. Files original certified copy of CP number 262 of 2016. The original certified copy of judgment dated for 2024. No, this was. All right, the opposite party husband files certified copy of civil proceeding of judgment dated 4/4/2024, passed in civil proceeding number 262 of 2016 by the learned judge, family court, Cuttack. Same be kept on record. Other history.
সেটা কেবল only soft copy টা আছে তার হাতে করছে না
So list this matter, what a date kar do.
2nd September
2nd September. Arratar koruntu. Learned counsel for the Sri B.K. Ghodai, learned counsel for the opposite party submits that the case in the court below has been disposed of and that he shall file certified copy of the judgment. List this matter on 2nd September.
So এটা টিকে লং ডেট কাই নাম
2nd September যদি হবে দরকার হবে কোন
কেস মাল item 25
Password item 21 mile. One week time is given to file a rejoinder mile.
The password is lock up mojiro হবে
Mile.
I don't know.
Appearing for the petitioner, as per the last order, in spite of sending process requisite, postal notice has been sent to the opposite party. So praying for 1 week time to give the process requisites.
Requisites for issue of notice through court process
Yes,
be filed within a week.
oblige.
The previous order be complied with.
I don't know 26 yes but in this case I have the opposite party the petition will not explain the delay the conduct delay not properly explained that was the order passed by the civil judge junior division civil judge senior division at 26
The report of the mediator indicates that mediation between the parties was unsuccessful.
This is clear. Upon
I'm sorry
Yes, who's appearing? Mr. Balkrishna?
Yes, Your Lordship, just prefer one passover.
I am appearing for the opposite party.
He's asking for a passover.
One
Passover.
item 27
Item 27.
here the petitioner has filed a petition for transfer of this application 51 of 22 from Balangir to Raulkela to Balangir. Here notice once notice has gone it was returned back that
Serve a copy, he will serve to the police or
I
let an extra copy of the transfer application be served upon Leonard State Council, who shall cause the same to be served upon the opposite party through the IAC of Kothana. Address kon dechindi. Through
the PS
Sector 7,
Raulkela.
Sector 7 Police Station, Raulkela. Will this matter on
7th August
27th August?
item 28
May I please, Your Lordship? This is a matter, Your Lordship. On behalf of Mr. P.R. Singh, may I be permitted to submit, Your Lordship? Mr. Myra.
My Lordship, I am appearing for Mr. Jaina. My Lordship, they have filed written note of submission and we will file the reply to the let the matter.
Reply to written note of submission.
Friday, my Lordship.
No. Reply to written note of submission.
No, we will examine the things.
Oh, no. All right. You
No,
may
no,
take
my
that.
Lord, he is repeatedly seeking.
No, my Lord.
On that last time also.
Even the room, Jonakun.
Last, Your Lordship will go to the order city, Your Lordship.
Okay.
And the matter are listed
Mediation ରେ ଯାଇଥିଲା ଆଉ
Very essential capability. It is only a simple matter. You also to be transferred the matter 138 matter which is pending in Malkanagiri has to be transferred to the Dhanakalal because both the parties are from the resident of Dhanakalal and Cuttack. Witnesses are also from these places. So it is only to harass the accused petitioner. He filed a case, deliberately filed a case in Malkanagiri.
All right.
The Lordship has heard this matter at length also.
I'll call it on 26th. I'll call it on 26th or on 25th. 26th तक हम छुट्टी तो हमारा हो जाए.
No further adjournment.
Yes.
Well, no further adjournment.
Yes. Therefore, adjournment is made on behalf of Sri Jana, learned counsel for the opposite party, which is opposed by learned counsel for the petitioner. List this matter on 26th July. It is made clear that no further adjournment shall be granted.
Item 29. Yes, I am for the petition, my lord. Petition of my lord. So, for to transfer our CM's case number 16 of 2022 from Law and Family Court.
Who is for the other side?
Look, I am for the husband. Let them appear for conciliation so that series of cases have been filed before different courts of law.
Mediation.
କିଛି ଦିଅ ତ ଆମେ ଝାରସୁଗୁଡ଼ା ସେ
ଆଜ୍ଞା ଆସନ୍ତୁ କନସିଲେସନ ଅଲ ଟାଇମ୍ ଟୁ କମ୍ ସେଟଲ ହେଇଯିବ ଏ ଚାରିଟା ପାଞ୍ଚଟା କେସ୍ ଫାଇଲ ହେଇଛି ଡିଫରେଣ୍ଟ କୋର୍ଟ
ଆଜ୍ଞା ଆମର ପଢୁଛନ୍ତି ପାଠ ଗୋଟେ ଝିଅ ଗୋଟେ ପୁଅ ପାଠ ପଢୁଛନ୍ତି ନାଉଡେଜ ୟୁର ଲର୍ଡସିପ୍
What? Nowadays what?
ଯାହା ଖର୍ଚ୍ଚ ବାର୍ଚ୍ଚ ପିଲାଙ୍କ ପାଠ ପଢା ଜଣେ କ୍ଲାସ 9 ରେ ପଢୁଛି ଆଉ ଜଣେ କ୍ଲାସ 5th ରେ ଷ୍ଟାଣ୍ଡାର୍ଡ 5th ରେ ପଢୁଛି ଆମେ ଯୋଉ ପ୍ରକାର ଖର୍ଚ୍ଚ ମୁଁ ଗୋଟେ ସ୍ତ୍ରୀ ଲୋକ ଆଜ୍ଞା
ଏଥିରେ ପିକୁଲାରିଟି ହଉଛି 46 of 2024 ଏଟା ଟ୍ରାନ୍ସଫର ମାଗିଛନ୍ତି ଝାରସୁଗୁଡାରୁ ଭଞ୍ଜନଗର ଆଜ୍ଞା 47 ରେ ମାଗିଛନ୍ତି ବଲାଙ୍ଗୀର ଟୁ ଝାରସୁଗୁଡା
ଆମେ ଏବେ ରହିଲୁଣି ଆଜ୍ଞା ବୁଗୁଡାରେ ଯେହେତୁ ଏବେ ବୁଗୁଡାରେ ରହିଲୁଣି ପିଲା ଦିଟି ଆମର ପାଠ ପଢୁଛନ୍ତି ବୁଗୁଡାରେ ଏବେ ରହିଲୁଣି ସେଥିପାଇଁ ଆମେ ସେଠି ଟ୍ରାନ୍ସଫର ଚାହୁଁଛୁ ଆଉ
ଯୋଉଥିରେ ଟ୍ରାନ୍ସଫର କରିଥିଲେ ସେଟା ଡିସମିସ୍ ହେଇଯାଇଛି ମୁଁ ସେଥିରୁ ବି ସେଗୁଡା ବି ଚାହୁଁନି ଟେକ୍ନିକାଲି ମୁଁ ଚାହୁଁଛି ଅଲ ଟାଇମ୍ ଟୁ କମ୍
Then we'll fix it to High Court Mediation Center.
ଆଜ୍ଞା
In course of hearing it is said.
second case.
Yes.
47 ରେ
47 second.
For the husband.
No, wife. Another proceeding.
Anyway, both cases, once mediation takes place, all the cases will be covered. It is stated at the bar that the nature of the dispute is such as can be settled through, as can be attempted to be resolved amicably through the process of mediation. Hence, the case records be placed before the coordinator, Odisha High Court Mediation Center, who shall do the needful. The parties are directed to appear.
9th.
No, pursuant to notice issued by the mediator and to render full cooperation in the mediation procedure. Please this matter on 27 September.
One thing, Premalo. Oh, ରାସ୍ତା ଝାରସୁଗୁଡାରୁ ଆସିବେ ଏଠୁ ଆସିବ ଆଜ୍ଞା ବୁଗୁଡାରୁ
My lord, item 28 interim order to continue.
Item number 30.
Item 30 no yes are not back, my lord. Notice issued. Yes are not back.
କେବେ ନୋଟିସ ହେଇଥିଲା ଏବେ ହେଇଛି ଏକ ସାଥରେ ନୋଟିସ ହେଲା through court process.
Once notice returned,
Let this matter after SR.
interim order to continue.
After SR of notice is back. Interim order to continue.
Item 31.
Oblige.
And for the petitioner, the petitioner filed his application for transfer of the suit from Kendrapada to Cuttack. The lordship find the plaintiff himself resides at Kendrapada.
Who's at the other? Who's the for the other side?
Other side. Last occasion they have filed the counter.
Let us pass it over. Pass it over.
I have some work after launch.
We'll take it up tomorrow. None comes for the petition is present. None appears for the opposite party. Let's this matter tomorrow.
Item 32.
I will pardon to item 30.
No, Pochwan. No bag here.
They have not copies of
No, nothing. Whatever you make. No bag here. So, Sala pare pass over raka. Yes, item 32.
Item 32.
Pass over.
Item 33.
Pass over.
Item 34.
34 may be passed over here requested.
All right, pass over.
Item 35.
34 right?
Pass over. Him agli pass.
File this petition transfer the case from Pattok, family judge Pattok to family judge Raurkela. I am staying at Raurkela.
Who's for the other side? Anybody is appearing for the other side? All right, pass over.
One go.
No calls.
Item 36.
In that case, I am appearing for the opposite party husband. Section 9.
Who's for the petitioner?
I mean, VC, my lord. My lord,
Yes.
My lord, the matter is pending before the learning judge Banki, civil learning judge.
You are filing.
My lord, I am applying for the opposite party husband.
You are filing any counter?
Yes, my lord. I will not. Let it be 1 week after, so that I will file my counter.
As requested by learned counsel for the opposite party, list this matter
12th August.
on 12th August.
My lord, the matter is posted on 3rd August in Banki.
Section 9 application, I have
All right, all right.
section 9 application.
All right, you may seek adjournment.
My lord,
Adjournment, huh?
the privilege.
Item 37.
May I please, your lordship, I pray for and pass over on behalf of
All right.
Grateful lordship.
Item 38.
38 correction be made accordingly. देखिए कोई correction कर लो.
Item 39.
Application of extension of time. Last time, the health condition of the husband of the petitioner, neurological problem, suffering from. Have annexed the medical health condition of the
1 month interim bail was granted.
granted last time. And the health condition of the husband of the petitioner, neurological problem, my lord.
Yes, that photographer, Your Lordship, yes, wanted from. Your Lordship was not inclined, but take into account some. All right.
So sacrifice के ही मतलब से.
All right. Copy भी देना. Considering the submissions and the interim bail granted by the order dated so and so is extended by a further period of 2 weeks. Yes.
4 weeks.
No
3 weeks.
further
3
extension.
weeks. 3 weeks.
Yes.
Item 40.
Name of the PS and name of the court has been wrongly typed.
Mistake from your end.
My lord.
The 2023. It has the court.
Sir.
Huh? Learned counsel for the petitioner is permitted to correct the typographical error in the cause title in court.
My lord. And the extension of date.
The order will be corrected accordingly. 2 weeks further time.
Item 41.
My lord, same.
Same.
My lord.
Item number 42.
The order dated 17/1/24, in the para 4, offense portion, there is a typographical error. 313 and 323, but it has become 323, 320 twice.
फिर कितना होगा 330 का होता है
313, 323.
in order dated 17/1/2024 in paragraph 4 the offense under section 323 as occurring twice be deleted and the following be inserted along with the other offenses. Section 313/323.
323 ଅଛି 313 ଅଛି ଯଦି ଦିଟା ହେଇଯାଇଛି 323.
ସରିଲାଣି ଅର୍ଡର ହେଇସାରିଲାଣି.
ଆଜ୍ଞା.
Item 43. Item 44.
May I please, Your Lordship? Your Lordship's last order, my lord, 25/24, my lord. Kindly glance to order dated my lord 25 para 6.
Para 6.
My lord, para 6 and 7 months. Your lordship be granted interim bail for a period of 1 month. And ଗୋଟେ ମାସ 3 ମାସ ଗୋଟେ 1 ମାସ ଲେଖା ହେଇଛି
1 month ତ ଦିଆହେଇଛି
7 ପରେ kindly see my lord.
3 months ହେଇଛି ଆଚ୍ଛା
ଆଜ୍ଞା
the considering the submission also the words 1 month occurring in paragraph 6 be corrected as 3 months.
Item 45.
Password very okay na the
Item number 46.
Offense under section 20B2 of the NDPS Act.
particular 40
2022. In this case, co-appeal granted bail 2 months.
Biswanath Khilo. Same order?
Yes, my lord.
Critically NRs out of correction for 80. Council का नाटा correction कर दिया ठीक है जी काउंसिल का नाटा करेक्शन करो तो आज्ञा कौन आज्ञा देखुछंती पैराग्राफ देखुनांती मिस्टर स्वान सो सबमिट से लिखा है आपन ना कौन
मंगू नंदी
आज्ञा
मंगू नंदी
मंगू
नंदी
लिखा है मंगू नंदी बोली कोठी आ कौन लिखा है
एनआर साहू
सीट तो चेंज कर देबे आज्ञा कथा वेरी सिंपल
Lordship, interim bail.
चीज आछि से
Yes.
Item 47.
47 पासवर्ड बोलारम को रखियो मु ये साला पर जिबी
फर्स्ट टाइटल मैडम
यस
पेज 1 ऑर्कल पेज 81 of 2022 हो
कोई 48
टाइपिकली 2024
आइटम 48
आइटम 46 रे
हां
सेटा टाइपिकली रॉन्गली 2024 ऑर्कल पेज 81 of 2022 हो 2024 कर दी
ये तो करियो बनी 24 टा
wrongly typed 2024.
The learned counsel for the petitioner is permitted to correct the typographical error in the cost title of the bail application in the office.
Item 48.
Please, your lordship. The
Pardon, my
co-accused
lord.
person-
47 password.
47 password.
Mark.
Co-accused person similarly situated have been released on bail by my lords, my lord. Number is there, my lord. The basis of their release is co-accused statement. They have been implicated. Here also the same situation. The 4 persons they are gossiping on the Bansadhara bridge. They all went and one of them fired and Gauri Prasad expired, my lord. Thereafter, my lord,
Who is this person? What is the allegation against him?
Is Munna Lima. I have to verify.
Yes, yes, yes.
That
From the case
Supari
diary.
killer B Raja he has fired, but what is their role? I have
So
to
you
verify.
obtain the case diary, will see.
Yes, my lord.
Up to date case diary be obtained. Khali case diary be obtained. Let's this matter 2 week for the 12th August. Yes.
Item 49.
May I please, Lordship? Your Lordship, I am appearing on behalf of the petitioner. The incident IA has been filed for the rectification in the nomenclature of final order sheet. Lordship, TRP was filed, a transfer petition filed in the nature of TRP civil, but in the final order sheet, it has been mistakenly reflected as TRP criminal. So I pray for the rectification, Your Lordship.
The order should be corrected to indicate TRPC instead of TRPCRL.
Oblige, Your Lordship.
Item 50.
I am seeking for modification.
28/11/2023 সেটা কেতে হওয়ার কথা
8/1/24.
The date 28/11/2023 occurring in paragraph 5 of order dated so and so be corrected as
8/1/24.
8/1/2024.
Oblige.
May I pray your lordship may keep it to day after tomorrow so that I will verify. I am having the document, but let me verify.
As requested by Mrs. Jena, learned counsel for the petitioner, let this matter day after tomorrow.
Day after tomorrow?
No, day after tomorrow.
Oblige.
So item note 16.
May I please, Your Lordship? I'm on behalf of my associate Pradhan. Last occasion, my lord has directed to file the written note of submission that I have prepared, my lord. Fact remains in the case, my lord. The petitioner was appointed in the year 1978. Subsequently, he has
What are you
been
challenging?
that period which I have been terminated by virtue of the order of this Hon'Ble Court under Annexure 3, I have been reinstated with the condition that I will not get the back wages. So far, the other benefit is concerned that is available at page 27. The period, however, may be counted for other benefits as available to the petitioner under law. That period they have not counted, not given me the benefit. And the similarly situated person by virtue of the order of different courts of this Hon'Ble Court, it is well decided because that GIA order for a particular percentage of mark, those who have not secured subsequently they have terminated. It is a reported case in 3 to 4
Mamata Mahanti.
Exactly. Mamata Mahanti, Manjushree Patnaik, and another 3 persons are there.
Probably from the date of acquiring.
Exactly. That is the law. That I have given in my written note of argument. That will be taken care of.
So,
that is well decided.
So what is, just briefly tell me the facts. Can we dispose of today? I think pleadings are complete, everything is there.
Okay.
Just please.
May some.
You have amended also your writ application.
Okay.
You have amended.
Okay.
Consolidated petition has been filed.
Yes.
Just briefly recapitulate the facts.
The petitioner was appointed in the year 1978 in the Barampur City College. Subsequently, they came under the grantinent aid in the year 1984. So when the circular came, the persons, those who have not secured more than 54%, they cannot continue. So subsequently, with the due permission of the authority in service, that we have given that upgradation examination, and I have secured 58.7, which is at Annexure 3, that is not disputed. So I have challenged the same. When I have challenged the same in this Honorable High Court under Annexure 4, pass the specific order in page 27, the operating part. I am reading out that it will clarify the situation.
27.
Again, page 27.
Yes.
That in that view of the matter, the appointment of the opposite party number 4 to the post of lecturer in history in the college in question must be quashed. OP number 4 was appointed, and we accordingly quash the same. The petitioner must now be permitted to continue as a lecturer in history in the college in question. But in a peculiar fact and circumstances of the case, the petitioner will not be entitled to any vacages for the period for which he has been kept out of service. The period, however, may be counted for other benefits as available to the petitioner under law. So then they have also make arrangement in the next para, since the opposite partner 4 has no role to play in this entire episode, and 8 has been decided in a victim of the circumstances have been appointed persons to an open advertisement. Being a duly qualified candidate is not required to vacate the post pursuant to our judgment. We would observe that the educational authorities may consider his case for suitable observing in any other educational institution. By the process, the OP number 4 and the petitioner, present petitioner, has been observed the college in question and another person in different educational institution by virtue of this judgment. When the judgment is in force, may kindly have a glance Annexure 5. So order was passed because by virtue of this order, they have not given any appointment. So contempt was initiated. By virtue of this contempt order in 95, I have been given appointment. So it is at page Annexure 5. Thereafter, while I was continuing as such, I have so far this breaking period is concerned where I was out of my service, that has not been considered for other purpose. And by virtue of the judgment of this Honorable Court, which is available at Annexure 11, the similarly situated person, even the person who is in different faculty of the same college where I was working and retired subsequently, they have also given that order allowing the petitioner to get all these benefit. Kind of a glance to page 45 for a moment.
Anyway, this the directed this division bench directed the authorities to consider your representation.
Exactly.
So have they rejected it?
No, in the meantime, I have retired from service. I'm not getting, because 2008 Mira. And I'm not getting any benefit so far. Even though despite of this series of judgment of this honorable court to consider that.
So it should have been counted according to you, it should have been counted for the purpose of pension and other benefits.
Because that back wages I will not entitled to get, because
that is already finalized.
That is not at all disputed.
Yes.
And to that effect, the judgment exactly Malars has pointed out. So for the Mamta Mandi case is concerned, which has been upheld by the Supreme Court, Madhav Chandra Mishra, that judgment I have given, and Manjushree Patnaik, State of Odisha, which is reported in 2006 to Ola, and Gopinath Panigrahi, that judgment I have given.
No, here that may not be necessary also. Here the simple case is whether that that period during which he was terminated.
Exactly.
Yes. For which he is not entitled to back wages. That this division bench has made it clear. But said that it will be counted for the purpose of or for other purposes.
Exactly.
Other purposes includes pensionary benefits.
That is my sole prayer. And I am relying upon that judgment because actually that fact, so far this 54% less and above of the can, all these criteria.
That is relevant. That has been taken note of by the division bench. Division bench has set aside your termination order.
Yeah, exactly.
So that is no longer
absolutely.
So only
similarly fact that has been taken care of by this one is my kind
has your application been rejected anywhere?
They have not considered. Series of applications are there.
Because there was an order, again, an order under annexure as I find, probably annexure 7.
In annexure 7.
You had again approached this court. I find that in another direction.
Again.
Where you said that one Gopinath Panigrahi had.
Gopinath Panigrahi.
So without entering into the merits of the case, you have to consider the representation of the petition in accordance with law on its own merit. So what have you said in your counter?
We have taken only the ground that it has been long delayed. The cause of action, though was available, it was to be taken long time back.
No, this order, this division bench order,
yes,
was supposed to be complied with by you.
Yes.
In fact, series of things happened.
Persistently, I am pursuing.
He also filed a contempt application. There is a contempt application also.
Again. Then and thereafter, I have been allowed to resume in my duty.
This writ application has been filed in 2018 undoubtedly.
Again,
yes.
18.
There is some delay. But I am closing it. Yes,
no, only he taken in the
but
counter.
delay ordinarily, yes. But here I don't think that you may be having that Tarsem Singh in your mind. Or the government may be having Tarsem Singh.
Yes.
But I don't think Tarsem Singh. Let us see whether it is applicable. All right.
May I submit the notes of
please? Hearing concluded. Judgment reserved. Learned counsel for the petitioner has filed a written note of submissions in court. The same be kept on record. Yes.
So item number 19.
Pray for 2 weeks time file rejoinder.
2 weeks time is allowed to the petitioner to file rejoinder. List thereafter.
Okay. So item number 21.
1 week time is given to file a rejoinder.
1 week time is allowed to the petitioner to file rejoinder.
Much of placement.
List thereafter.
So item number 26.
Item 26. The previous order we seen, there was a mediation at the
Mediation has failed.
at Parlak meeting.
Mediation has failed.
But one thing, what as per the instruction of the petitioner, he is ready to willing to join him. He came, said, I don't want to take, and he left. That is the thing. But the mediator did not take any step.
See, this court cannot pass
No,
any
no,
comment on that. The only thing is that this court will note that the mediation has failed. So the transfer application will be taken up.
what I humbly submit, can it be taken up before the mediation of Orissa High Court?
It has already been, mediation has
Accepted
failed.
twice when she is willing to join him. So what is the reason for not
What do you say?
accepting?
Call it. A report of the mediator, report of the mediator appointed by the DLSA, District Mediation Center, Gajapati, indicates that mediation between the parties was unsuccessful. What's it, Gajapati? Has failed. Sri P. Balakrishna, learned counsel for the petitioner wife, however, submits on instructions that his client is ready and willing to join her husband, and that further attempts be made to resolve the dispute between them amicably. Learned counsel for the opposite party husband has no objection. In such view of the matter, let the records be placed before the coordinator of Odisha High Court Mediation Center. Release this matter on 9th September.
Interim order to continue.
Interim order to continue.
So right now 32.
My lord, last occasion notice issue, and it was listed last week also, nobody appearing today.
We will take it up.
My lord.
When the counsel for the petitioner is present, none appears for the opposite party. On the last occasion also there was no appearance. Hence the transfer application is taken up for hearing. Yes.
Transfer the case from Rayagada to Gajapati. The one baby child, my lord, 1 year, 5 months.
The petitioner wife seeks transfer of CP number 38 of 2024, pending in the Court of Learned Judge, Family Court, Rayagada, to the Court of Learned Judge, Family Court, Gajapati at Parlakhamudi. Therefore, transfer has been made on the ground that the petitioner is presently residing at Parlakhamudi and has been blessed with a baby girl. As such, it would be difficult on her part to travel to Rayagada to attend the court on the dates fixed. Having regard to the submission as above and the ground on which the transfer is sought, I am inclined to allow the same. It is directed that such and such.
So right now 33.
May please, Your Lordship. Notice was directed to be issued as per order dated 4/6/2024.
List this matter next week along with the latest or up-to-date postal tracking report.
There is no order in this case, IA. So
Adjournment. Adjournment. The postal tracking report only shows that item bagged. So ता परटा आसिनी हो.
So right now 34.
But petitioner is the wife prays for transfer of CP filed by the husband under section 9 of the Hindu Marriage Act.
Anybody appearing for the opposite party? Somebody has appeared.
List shows that.
Learned counsel for the petitioner is present. There is no appearance from the side of the opposite party, though he is represented by a counsel. Let this matter next in order to grant another opportunity to the opposite party to appear. Let this matter next week. Yes.
So right now 35.
File this petition, civil proceedings number 174/24 from the Court of
35 same order for those. Are weak ratio because the other side is not there. Just one more opportunity will be.
So right now 37.
My lords, in this, I have some allegations have been made against the governing body. I have obtained the oral instruction. I will just ascribe them to that because we inquired. There is allegation that the postal, the registry post that was sent, that was refused. My information, what I have gathered, that the school used during these periods, school used to be closed at 10 a.m. Therefore, I have asked that they have inquired from the postal authorities who has refused it because these allegations are there. Therefore, my lords, it is to be slowed down because the deponent to the reply is not well to. That's why it could not be.
No, but this is a disposal of matter.
Disposable matter. He has made he has made a prayer for giving some benefit to the petitioner, the opposite party.
You are the petitioner in this case.
My lord?
You are the petitioner.
No. I was the petitioner in the writ application. Now the IA has been filed by the opposite party from whom your lordship have given a direction that either of them are to allow to remain and some of the other person is to be placed some other in the school. Now he has made this application that he filed the joining report, but that was not accepted. He sent it by the registered post, that was refused. All these matters needs to be clarified because I am to give a reply there too because allegations are made.
Which IA can you please?
6038 of 2024.
6038 जोटा देखिली सेथरे अछि application for appropriate order and for fixation of time limit for compliance of the order of the appellate authority. So that has been filed by opposite party number 5.
Yes, ma'am. No, this is filed by opposite party number.
Respondent number 5 लिखा है.
Yes, respondent number 5. I've
He wants to join in the previous. How?
My lords, I am to give a reply because he has he has made allegation against that the postal receipt was refused. That needs a reply, my lords. Because we have inquired from the postal authorities, it may request some time. My lords, my happy to 29th or 30th. That's not difficult. During that period, I will be able to.
List this matter next week, as requested by learned counsel for the petitioner. Yes.
So right on 43.
My lords have fixed up to
29. 43.
Sorry, item 30. Has been passed for SR. Already for the sole respondent, I have already appeared as caveator. So in the last date of listing, they were directed to supply me copy. Till today, they have not supplied.
Certificate कौन है? अर्जुन है. Item perspective जहाँ अर्जुन है जिस तरह का लिखी दूँ तो the opposite party has already entered appearance through Sri Prafulla Kumar Jana. Copy of the transfer application be served upon him and his name be reflected in the cause list.
Sir, Lordship, item 23.
No, wait.
So,
yes.
Sorry, Milord, I beg to pardon, Milord. Due to misguidance of the court below advocate, Milord, petitioner not to join the IO only one day join.
Pursuant to the last order, Lordship, the instruction. The Lordship directed every alternate day, but has not appeared and only on the last occasion. Learned State Council has obtained instructions that the petitioner had appeared only once at Plant Site Police Station on 15/7/2024 and not thereafter. Learned Counsel for the petitioner files surrender certificate indicating that the petitioner has surrendered to custody on 16/7/2024. The surrender certificate be kept on record. Oh, city file. Surrender certificate be filed in the office, in the counter. That's all.
File to 100 extension of
extension what? Surrender extension what? Because then he has already surrendered.
16 तारीख दिन पूरी अब मिसकैश फाइल कर दे
आपण फाइल करिवे देखा जिवो
ना फाइल करछे ऑलरेडी सेटा पेंडिंग अछि
कोन करे जो आपण कंडीशन मानिबेनी
ना ये ड्यू टू मिसगाइड ऑफ द लोअर कोर्ट एडवोकेट मिला
सो ही विल सफर
मु 15 तारिख दिन ताको जो लिस्ट उठला मु से फोन कली सांग से जाई हजूर से कला आउ से भूल करी
नहीं से भूल करछ हबनी
ना अंडरटेक
नहीं से था यस
मेन बेलटा सुहियरिंग पई
1 week after.
Is this matter 1 week after?
No, that may be possible.
Well, date. See, देखिए. Yes.
So item number 45.
45. None appears on repeated calls. Is this matter when moved?
So item number 47.
Same. Really? 2 PM to हाँ. Yes.
Lordship, item 23 and 24.
23 and 24 कौन है जी?
Petition I prefer next week, Lordship.
23 and 24? একজন হিচ with
2nd September.
2nd September.
Interim order to extend.
Yes, interim order to continue.
Weekly list item number 1.
तेरे को अच्छी में लिखा देख लो क्यारी देख लो तो लिखा रखा अच्छी Yes, sir. नहीं no था. Yes.
But made clear.
Yes.
The defendant is the appellant for lordship. In a suit for declaration that the sale deed dated 16/3/1993 is to be set aside, and declaration of the plaintiff and the same sale deed is not binding on the plaintiffs, and for declaration of title and confirmation of possession. But here, if your lordship looks at, the plaintiff claims that this is an ancestral property. So the property has already been divided between the grandfather and the father inherited the property. First thing I would like to submit for lordship is that once the property gets partitioned and one of the co-sharer gets the property, it becomes his own property. It cannot continue with the ancestral system after the partition is effected. Once partition is effected, it loses the character of ancestral property. Therefore, the father has got a right to alienate the property once the property has come to him. The children during the lifetime of the father cannot challenge the sale deed executed by the father. This is the first point I would like to raise.
Provided the partition is either proved or admitted.
They themselves say there has been a partition.
All right.
It's a plaintiff's case that there has been a partition.
So that is what I'm saying, either proved or admitted.
Admitted. So Hindu law says that the Karta of the family, even if it is not partitioned, has got a right to alienate the property.
For legal necessity.
For legal necessity. Therefore, on 2 grounds, I would like to say the plaintiffs who are the son of defendant number 5, who challenge the sale deed executed by defendant number 5 in favor of defendant 1 to 4, cannot be sustained. They have further asserted that the sale deed that has been executed by defendant number 5, he has not received any consideration money. Therefore, the sale deed is bad. And there was no legal necessity. Now, sir, kindly look at section 91 of the Evidence Act. Read with section 92. The recital of the sale deed is binding on the parties.
If it is clear and unambiguous.
Clear and unambiguous. Now kindly look at Exhibit A.
LCR টা বাহার করলে হবে as usual. খরাপ পড়বে সে বিলকুল Exhibit A. Yes, yes, I have it. Sri Narayan Upadhyay.
Yes.
Anant Upadhyay was
1993.
16 to 1993. Yes.
16 to 1993.
Yes.
He is different number 5, Narayan Upadhyay, executed in favor of Vidyadhar Padhi, Birendra Padhi, Dhirendra Padhi, Ravindra Padhi. The recital says, Kasya Jami Vikraya Kavala.
What is the meaning of Kasya?
Sir?
Kasya or meaning type?
Barthaman, present.
The co area of
it a Baripada. No, Baripada no. Consider.
Baripada is it? Belakuti Morvan. Morvan is your Basata.
No, it a Baripada no.
No, Morvan is like Morvan. Kasya Jami Vikraya Kavala. Patramidam Karjo Karjan
Kavala Patramita Karja Exit Udala Thana Udala PS Udala Udala Sunso Kata Hutta Ossidismal Jami Ame Bikran to Name Ticord Daira Rohiachi Ukta Jamiku Ame Bortaman Sudha Nirbit Rode Bogo Dakhala Kari Asuachu Bortaman Amhe Bikragat Dena Parishoda Nimante. So when he has got some loan to repay, Tonkara business Dorkar Habaru. Ame Anyatro Upare Tonkar Jogada Kori Nopari Baru Ammo Namita Thiba recorded in his name. 80 decimal Jamiku Sirsokta Mutti Mulya 24,000 Tonka Jara Samanare ବିକ୍ରୟ କରିବା ପାଇଁ କଥା ସ୍ଥିର କରି ଜର ସମନ ବାବଦକୁ ସମସ୍ତ ଟଙ୍କା ଏଥି ପୂର୍ବେ ଆମ୍ଭ ବାସଗୃହଠାରେ ବୁଝି ନେଇ ଅଦ୍ୟ ତଫସିଲ ଜମି କ୍ରେତାମାନଙ୍କୁ ବିକ୍ରୟ କରିଦେଇ ଦଖଲ ଓ ଚିହ୍ନଟ ଦେଲୁ। ଉକ୍ତ ଜର ସମନ ବାବଦକୁ ସମସ୍ତ ଟଙ୍କା ହାସ୍ୟା ଲିଖିତ ସାକ୍ଷୀମାନଙ୍କ ମୁକାମରେ ବୁଝି ନେଇଅଛୁ। ଅତ୍ୟ ଦିବସ ଠାରୁ ଆମେ ବିକ୍ରେତା ଏହି ବିକ୍ରିତ ଜମିରେ ସମ୍ପୂର୍ଣ୍ଣ ଭାବେ ବେଦଖଲ ଓ ନିଃସତ୍ତ୍ୱବାନ ହେଲୁ। ଆଜି ତାରିଖ ଠାରୁ କ୍ରେତାମାନଙ୍କୁ ଦଖଲକାର ଓ ସତ୍ତ୍ୱବାନ କରାଇଲୁ। ଅଦ୍ୟ ଠାରୁ କ୍ରେତାମାନେ ବିକ୍ରିତ ଜମିକୁ ଯେତେବେଳେ ଯାହା ଚାହିଁବେ ତାହା କରିପାରିବେ। ବିକ୍ରିତ ଜମି ଆମେ ଏଥିପୂର୍ବେ ଅନ୍ୟ କୌଣସି ଠାରେ ହସ୍ତାନ୍ତର କିମ୍ବା ଦାୟଯୁକ୍ତ କରିନାହୁଁ।
So consideration, you wanted to show the consideration.
Okay.
So there is an endorsement that there is a clear recital according to you that
he has received
it prior to execution.
Prior to execution.
All.
So actually, defendant number 1 to 4 and defendant number 6. 6 is the person in the record of right, his name finds place as illegal possession holder. D6 comes to a plea that the property was sold by defendant number 5 in his favor by oral sale. 1959.
Yes.
But that has been disbelieved by the court. D6 is one of the attesting witness.
Yes.
They wanted to show that the entire consideration money, oral evidence, entire consideration money has been paid to defendant number 6, who paid it to defendant number 5, and sale deed has been executed. The court has taken exception to this, since the evidence shows the consideration has been paid to defendant number 6, and he has paid it to defendant number 5. Therefore, D number defendant number 5, the vendor has not received the consideration.
once plaintiff has failed to prove, defendant 1 to 4 has failed to prove that the consideration has been paid to defendant number 5 and he has received. Therefore, there has been no consideration has been paid. Once consideration has not been paid, sale deed is invalid.
Yes.
So fact remains that D6 was impleaded as a party by the plaintiff, not by defendant 1 to 4. They are defendants.
Yes.
So they impleaded him knowing fully well that he was possessing the land, maybe illegal possession. Why D6 is one of the attesting witnesses in the sale deed? Because D6 was in illegal possession. Plaintiff D5 is to give delivery possession. That is the reason why he has been, plaintiff impleaded him as a party, and he has also a party to delivery possession. Otherwise, D1 to 4 would have filed a suit for eviction against him. So this land is in front of the house of defendant number 1 to 4. So they can only approach the main road after they purchase this land. That is their case. So if this land goes, there will be difficulty for them to go to the main road in that area. So that's the reason why they have purchased the land which has been executed by them. If you also kindly look at the findings
of the trial court.
Trial court, same thing. So I'll show you lordship the appellate court finding.
Yes.
The inner page 7, paragraph 9.
Yes. Yes.
As regards the execution of the sale deed by pro forma defendant number 5 in favor of appellant, it is already held that suit land is the ancestral property of plaintiffs and pro forma defendant number 5. That finding, I have said that they admit that there has been a partition. Therefore, the father of defendant number 5 got the property in partition. Therefore, it loses the character of ancestral property. On the above background, the plaintiff have also equal right for the suit land, along with pro forma defendant number 5. Even assuming they have got a right to the property, D5 is the Kortad. Therefore, if he has proved legal necessity, it can be sold. And D5 has not filed any written statement to counter. No right to alienate the property without legal necessity. It is the case of contesting defendant that they have paid the consideration to defendant number 6. When defendant number 5 has executed the sale deed, being the vendor, there is no reason to make the payment of the consideration amount to defendant number 6, for which the plaintiffs have rightly contended that sale deeds was executed by pro forma defendant number 5 without any consideration. But the recital of the document says, Exhibit A, that D5 has received the consideration amount. Sir, I have paid it to D6. D6 paid to defendant number 5. Defendant number 5 says I have received. Therefore, court cannot arrive at conclusion that it was paid to D6 and not to D5.
Yes.
The learned counsel for the appellant urges upon the court during course of argument that pro forma defendant 5 orally sold the land to defendant 6 in 1959. In acknowledgement of the said sale deed, pro forma defendant 5 is executed on affidavit Exhibit G. In this connection, the plaintiff have also rightly urged that during 1959, the father of pro forma defendant 5 was alive, and at that juncture, the pro forma defendant 5 had also no right to orally sell the suit land in favor of defendant number 6. Apart from this, when defendant number 6, being the attesting witness to the registered sale deed, acknowledge the title of pro forma defendant number 5 in the implemented sale deed itself. So D6 cannot further claim is title over the suit land basing on the affidavit of 1988. Thus, the plaintiffs have successfully established that pro forma defendant of 5 had no absolute right to alienate the property either in favor of defendant 6 by way of oral sale or in the year 1993 by executing the register sale deed in favor of plaintiff appellant as well as the defendant of 5 to 7. Under the above circumstances, what the lower court has rightly declared the sale deed is invalid. So this conclusion, my responsibility is not correct legally. The oral sale may be disbelieved, but admittedly, sale deed shows D5 has executed the sale deed for legal necessity. And the definition of legal necessity as per Hindu law shows that to repay the debt is the legal necessity.
Antecedent debt.
Right.
Yes.
Now, the court themselves, in the appellate court, has also observed in page 8, top sentence one. Under the above background, not got it. The plaintiff have also equal right over the suit land along with the pro forma defendant 5, for which the pro forma defendant had no absolute right to alienate the suit property without legal necessity. That means if he has got legal necessity, he can do it. So here legal necessity is apparent on the face of the record. And alienation has been admitted by defendant number 5. He has executed. They have not disputed the sale deed. They say he had no authority to sell. And there has been no payment of consideration. These are the only two reasons given. When those two are established, prima facie, therefore it cannot be said that the sale is invalid in the eye of law. And title passes. Sir, had it been a case of plaintiff, in the guise of executing an agreement or in the guise of executing a some document or affidavit for the purpose of any other purpose, they have taken defendant 5 and by fraudulent manner, undue influence, got the sale deed executed, then matter would have been defined. Nobody can challenge a sale deed when the recital is unambiguous about passing of title. If you Lordship kindly see,
yes,
82 Supreme Court. Page 20.
20.
20.
Yes.
There are 2 points involved whether res judicata will apply or passing of the document can be challenged. Paragraph 11, Lordship kindly see.
Yes.
The next contention on behalf of appellant is that subsection 1 of section 92 of the Evidence Act bars the respondent from contending that there was no sale, and it is submitted that respondent should not have been permitted to lead parole evidence in support of the contention. Section 91 of the Evidence Act provides that with the terms of contract or of a grant or any other disposition of property have been reduced to the norm of a document, and in all cases in which any matter is required by law to be reduced to the form of a document, no evidence be given in proof of the terms of the such contract, grant or other disposition of property or of such matter except the document itself. Subsection 1 of section 92 declares that when the terms of any contract, grant or other disposition of property or any matter required by law to be reduced to the form of document have been proved according to the last section, no evidence in the oral agreement or statement can be admitted as between the parties to any such instrument or their representatives in interest for the purpose of contradicting, varying, adding to, or subtracting from its term, and the first proviso to section 92 says that any fact may be proved which would invalidate any document or which would entitle any person to any decree or order relating thereto, such as fraud, intimidation, illegality, want of due execution, want of capacity in the contradicting party, want or failure of the consideration, or mistake of fact or law. It is clear to us that the bar imposed by section 91(1), section 1 of section 92 applies only when party seeks to rely upon document embodying the terms of the transaction. In that event, the law declares that the nature and intent of the transaction must be gathered from the terms of the document itself, and no evidence of any oral agreement or statement can be admitted as between the parties as such document for the purpose of contradicting or modifying its terms. Subsection is not attracted when the case of a party is that transaction recorded in the document was never intended to be acted upon at all between the parties, and that document is a sham. Such question arises when party asserts that there was a different transaction altogether. It was for other purpose, but it utilizes the sale deed. And what is recorded in the document was intended to be of no consequence whatever. For that purpose, oral evidence is admissible to show that the document executed was never intended to operate as an agreement, but some other agreement altogether, not recorded in the document, was entered between the parties, and they are referred to another decision. The trial court is right in permitting the respondent to read parallel evidence in support of the plea, saying it did so and so with a sham document. This is not a case where they have cases that it's a sham transaction. But interestingly, the trial court, exactly the same ground it has been rejected, set aside the sale deed. But one, the sale deed remains as valid, title passes. Possession has been delivered in favor of the plaintiffs at defendant 1 to 4. For the finding of the trial court, I'll just show you lordship with regard to possession. I'm sorry. And see, inner page 19
of the trial court judgment.
Trial court judgment.
Yes.
Now in the middle portion, they are admittedly defendant number 5.
Yes.
Have you got that?
Yes.
Admittedly, defendant number 5 was the father of plaintiffs, and the plaintiffs have failed to prove that plaintiff number 1 was the karta of the family on account of illness of defendant number 5. A karta or a manager of joint family has a right to alienate a land for legal necessity and benefit of the joint family, and such alienation is binding of the members of the joint family. That is the legal position they have taken note of. In this suit, there is no legal necessity. I don't know, sir, how the court has recorded. In this suit, there is no legal necessity. Moreover, no consideration amount was paid to defendant number 5. On the other hand, deed was executed under fraud by defendant 1 to 4 with connivance defendant number 6. There is no proof of fraud or anything else. Fraud has to be pleaded and proved. And if fraud would have been committed, D5 would have challenged it. He was alive. He was made a party. 1 to 4, plaintiff 1 to 4 was children of defendant 5. They cannot challenge that fraud has been committed. when defendant number 5 is alive. And he should have been examined as a witness. That has not been done.
Yes.
Therefore, it is held that alleged sale deed executed in favor of defendant 1 to 4 is not valid. Moreover, no money was paid to defendant 5 to clear his loan. On the other hand, defendant 6 cleared up his loan. Therefore, the sale deed was not executed by pro forma defendant 5 for want of money to clear the loan. As discussed above, there was no legal necessity to bind the plaintiff, who are also member of joint family of which defendant 5 is the Karta. It is also admitted by defendant that defendant 6 delivered possession of the suit land to defendant 1 to 4, although he was neither the real owner nor he was in possession of the suit land. Defendant 5 had not delivered possession of the suit land nor received any consideration amount, as well as there was no legal necessity to execute Exhibit A. Therefore, it can safely be said that the sale deed by Exhibit A was never acted upon. Thus, it was held that the sale deed Exhibit A was never been acted upon accordingly. But possession has been delivered in favor of defendant 1 to 4. Why defendant 6 was there, they themselves made him a party. The note of possession was of defendant 6. Plaintiff defendant 4 admitted in the sale deed to have delivered possession. That means when possession was delivered, it was in the presence of defendant 6, so that he cannot subsequently claim that I am in possession.
That is also
plain and simple.
We'll continue after recess. Yes. We'll finish it today. He'll reply.
The possible necessary, I'll give one.
Yes.
ସେଇଟା କରିବେ ପଡ଼ିବ ସେ
You'll take some time.
Better.
Yes, Mr. Asset.
Yes.
It's not.
बंद करो बहुत मिनिमाइज करो मिनिमाइज करके सप्लीमेंट्री लिस्ट को आना सप्लीमेंट्री लिस्ट वो बंद क्यों करो
My learned senior is telling that I should be given the first audience, but 10 years ago he was enjoying that privilege for long 5 years. So now you are trying to shift the battle on my head, but I know it's a democracy.
Yeah, it is not, and it is also not common for a court to have the first hearing of an advocate general.
I don't know. It's not like that. I don't believe in that theory. Counsel is a counsel.
No, that's
the roles are different.
Yes.
Well, at this, before that, if your lordship would permit me, I'll make a mention 36 item. That is a property of Lord Sri Jagannath.
36 of?
Therefore, 36 of the which list? The old list. Huh? Weekly list. Lord, it's a second of it. 82 by 2003. Surendra Nath Patnaik versus Managing Committee, Jagannath Temple.
Yes.
Let it be taken off some other day. I just today assumed the office I was taking stock.
No, it's all right. But I'll adjourn it. But this is a 2003 matter, so you must give me a
not any date, not today.
No, not
because today it may be difficult. I have to go through.
No, it's not. So shall we take it up? Week commencing.
Week commencing sometime in first week of August.
5th August.
5th August.
Week commencing 5th August.
That will do. That will.
List this matter on 5th August as present.
So this election petition is directed.
Let me
so
first
for the-
begin. I must say that I must express that I am very new to this election thing.
That's correct. No, the procedure now it is to be admitted and notice is to be issued.
Yes.
That's
But
the.
is
that's
it in
the
order?
problem.
Let us see
No,
the SR.
no, it is coming for the first time.
Yes.
So your lordship is the election judge because this is assigned by the Honorable Chief Justice.
Yes.
So the main ground of challenge is with regard to the defect in the nomination, which was illegally accepted by the returning officer. So your lordship knows under section 100, 1C and D, these are the two grounds on which an election can be set aside.
Yes.
Your lordship may kindly turn to section 100 of the Representation of the People Act. Section 100.
Yes.
Grounds for declaring election to be void. Subject to the provisions of subsection 2, the High Court is of opinion that on the date of his election, a written candidate was not qualified or was disqualified to be chosen to fill the seat under the Constitution or this Act or the Government of Union, etc. These are the grounds on which an election of a written candidate can be set aside. We are, your lordship may skip 1A, B because we are not concerned. So C, your lordship may kindly come. That any nomination has been improperly rejected. We are not on that. This is a case of illegal acceptance of the nomination paper. That is D, covered by D. That the result of the election, insofar as it concerns a written candidate, has been materially affected by the improper acceptance of any nomination. We are on this. Section 101, clause D, subclause 1. This is the ground on which we have.
Why do you say that it was improperly nominated?
Improperly rejected because your lordship knows that following that Supreme Court judgment in PUCL, People's Union Association for Democratic Reforms, now every candidate is required to furnish an affidavit in the prescribed form 26 along with the nomination paper. It is mandatorily required. So any defect in the affidavit, like any suppression of pending criminal case or the property, or even our High Court in two cases, Jogesh Singh, Sunargarh, he was an MLA from Sunargarh, and recently of Kotak, Mohammad Makim. So defect in the affidavit with regard to suppression of any material which is required to be furnished is a defect of substantial character which renders a nomination invalid. But the Supreme Court has said at what stage the returning officer cannot do that. Even if there is a defect which is pointed out by any contesting candidate to reject the nomination on that score, the returning officer cannot do. Supreme Court says it is the election tribunal, means the Honorable High Court, who can go into the correctness of that aspect and decide whether it was properly or improperly accepted. So we are on that. There are judgments. So, my lord, today the formality is notice will go, other party will appear, he has to file the return and say respondent.
Check up the notice. No,
I'll check that. It's a private dispute. I can appear for any return candidate also.
Check up.
We'll check out. We'll check out.
So we'll just admit it?
Huh.
Issue heard, admit, issue summons for filing of written statement.
Name of Mr. Tripathi now.
Yes, I'm not writing any name.
That's correct.
I'm not writing any.
That's correct.
I simply said, that is why, had it been a second appeal, I usually write the names.
Correct.
That is why I simply said heard.
That's correct.
Heard, admit, issue notice,
check.
issue summons to the respondent. Respondent, how about that?
A respondent.
Respondent for written statement and settlement of issues.
Right.
I think it's like the civil
Right.
almost
It's like a civil suit.
fixing a returnable date 4 weeks after. 4 weeks after particular date.
9th September.
9th September.
9th September. 4 weeks, your lordship may, so that it can be expeditiously at.
No, I've said 4 weeks.
August.
4 weeks earlier, August.
22nd of July.
So last part of August.
Last part of August.
27th August.
All right. This is matter on 27th August.
27.
Yes. Requisites have already been filed.
Everything is, it is to be filed at the time of presentation of the.
Like a civil suit.
Like.
I hope to learn from the learned counsel appearing. Yes.
Quickly list item number 1.
Made, please, Your Lordship. I may be permitted to make my submission on behalf of my learned senior Mr. Das.
Yes.
In this matter, learned trial court issued framed as many as 11 issues.
You have heard the senior counsel.
Yes.
Crystallized the points of argument.
Yes.
Basically on 3 points, as I remember and as I understand. First is
Ancestral.
ancestral property and something which is admitted according to him.
Yes.
All right. And the sale deed is being challenged on certain grounds,
Yes.
which probably, according to him, is not available to be challenged in view of the clear recitals. There is no ambiguity in the recitals.
I will satisfy yours.
Yes.
First is whether this property is ancestral property or not. Law is well settled that even if there is a partition, my lord, it remains ancestral property for the issues. My lord, I rely on a judgment of Honorable Supreme Court.
Yes.
Reported in 2018, volume 7 SCC, page number 646.
Yes.
Paragraph number 12 is it. It is relevant for the.
No, first place the principle. So even if it is ancestral property?
Even if it is ancestral property after partition, in this case,
yes,
the grandfather of the plaintiff, he got that property in a family settlement, and my humble submission is, even if there is a partition, it remains ancestral property for the provided defendant number 5, the father of the plaintiff, and the plaintiffs as well, my lord.
So what is the effect of it?
But once it is an ancestral property, it cannot be transferred without the consent of the other co-personals, my lord, that the plaintiff's
consent.
My lord, only it is alleged that only defendant number 5.
Supposing there is a partition by meets and bounds.
Yes, ma'am.
You have been allotted a particular share of property. Let us say it is A.
Yes, madam.
You mean to say that you don't have any right to deal with it independently without taking the consent of your co-sharers?
Yes, ma'am. That is also Article 269 of the Hindu law by Mullah. It is very clear that without consent, father cannot transfer the property. It is very clear that it remains ancestral property. May allow me to.
Yes, please. Yes, please.
It is settled that the property inherited by the male Hindu from his father, father's father, and father's father's father is an ancestral property. It is well settled. The essential feature of ancestral property, according to Mithakshara law, is that the sons, grandsons, and great grandsons of the person who inherits it acquire an interest and the rights attached to such property at the moment of their birth. The share which a co-personal obtains on partition of ancestral property is ancestral property as regards his male issue. It can be extended to the female as after the judgment of Vinita Sharma and Rakesh Sharma as well. After partition, the property in the hands of the son will continue to be an ancestral property, and the natural and adopted son of that son will take interest in it and is entitled to it by survivorship. So that property, that the suit property, remains ancestral property for the plaintiffs. So they reserve every right to file a suit even if that sale deed is not challenged by the defendant number 5. This is my first fold of submission. My let me kindly turn to page number 11, paragraph number 6. The issue number 3 has been rightly decided by learned trial court.
Which one? You want the trial court judgment?
My lord.
Trial court judgment of page kete?
11, paragraph number 6.
Paragraph 6. Page 11 is, there is no paragraph here.
Clearly, but after the issues.
Yes.
Yes. The suit was once decided by this. So this is irrelevant, my lord. The suit was once decided by the court by judgment dated such and such. Thereafter, the plaintiffs filed appeal. As the suit was dismissed, in the appeal, the suit was remanded to the trial court again for the fresh disposal of with a direction to give finding on each individual issues. My lord, It admitted case of both the parties that the suit land was recorded jointly in the names of ancestors of the plaintiffs as well as defendant number 5, namely Basudev, Ananta, Radha Mohan, Jagmohan and Brajamohan, all the sons of Madhav Upadhyaya in the settlement operation finally published in the year 1942. It is not also disputed that the father of the defendant number 5, Ananta Charana, got the suit land in a partition between himself and his brothers, and that the suit land is recorded in the name of proponent defendant number 5 in the current settlement. The certified copies of the ROR to Exhibit 1 to Exhibit 3 also prove that the suit land is a part of ancestral property of the plaintiffs and defendant number 5. It is also not claimed by the defendant number 6 that the suit land is a part of his ancestral property, nor the document, that is Exhibit 1 to Exhibit 3, reveals anything that defendant number 6 has any interest in the suit land. So it is made very clear that it's a part of it is an ancestral property matter. My humble submission and the rulings of Hon'Ble Apex Court reported in 2018 at para 12, as I have pointed out, it is made very clear that it is an ancestral property. So plaintiffs had every right to file a suit even if it is not challenged by the defendant number 5. Being the co-partner of the family, it is rightly filed by the plaintiffs. Then your lordship may kindly turn to page number, the issue number 5, page number 21. Issue number 5 was framed that was the alleged
Page 21, I think it starts with issue number 7.
Page 21 of the trial court.
Yes, trial court order. Para 16, issue number 7. Issue number 5 is decided elsewhere.
I'm sorry, madam. Para 19. I'm sorry.
Para 9.
Page 19, madam. I'm sorry. Para 10. Issue number 5.
Yes.
May I read it? Plaintiff as well as defendant number 5 claim, defendant number 5's claim is that the suit land since is their ancestral property and a fraudulent sale deed of the suit land was obtained from defendant number 5. So the sale deed is void and not binding on the plaintiffs, and the defendant number 5 to defendant number 1 to 4 and 6 denied the same. Madam, may kindly come to, although not pleaded in the plaint. I'm sorry, madam. Lordship, may kindly turn to paragraph number 11. The very next.
You would just come to a little bit below. Although not pleaded in the plaint, plaintiffs have adduced evidence that defendant number 5 was sick and incapable of movements, for which plaintiff number 1, Madhusudan Upadhyaya, is the Karta of the family.
Yes.
This piece of evidence is inadmissible under the law for want of pleading to that effect.
Yes, therefore, the stand taken by the plaintiff that the Madhusudan Upadhyaya is the Karta of the family, defendant number 4 was sick and incapable of movement is not agree. It is already there, my lord. My lord, may kindly turn to paragraph number.
Let us come to basically this sale deed. You are challenging the sale deed.
Yes.
On what ground?
That the consideration amount is not paid to the defendant number 5.
I think the senior counsel has read out that your summon part. But what is ambiguous in it? Let us read it together again.
Yes. But section 58 of Indian Evidence Act cannot be ignored, your lordship. That is my humble submission, my lord.
That endorsement?
That
endorsement by
that they have admitted in their pleading, my lord, that the consideration amount was paid to defendant number 6, not to defendant number 5.
Maybe. ଜରସମନ ବାବଦକୁ ସମସ୍ତ ଟଙ୍କା ଏଥିପୂର୍ବେ ଆମ୍ଭ ବାସଗୃହରେ ବୁଝି ନେଇ ଅଦ୍ୟ ତଫସିଲ ଜମି କ୍ରେତା ମାନଙ୍କୁ ବିକ୍ରୟ କରିଦେଇ ଦଖଲ, ଏଟା ଏଷ୍ଟପଲ ହବନି? Will this not act as estoppel?
But the admission they made in the written statement itself, that the consideration amount was paid to defendant number 6, not to defendant number 5.
But
the consideration amount being one of the essentials of the sale that is defined, as your lordship knows, in under section 54 of TP Act. It is one of the essential condition of the sale.
True.
That it has not been paid to the defendant number 5. Defendant number 5.
I pose a question to you. Supposing execution of a sale deed is admitted.
Yes, ma'am.
Then it is registered. That registration is also admitted.
Yes, ma'am.
The consideration has not been paid.
Yes.
Will it completely invalidate the sale deed?
That I need to examine that position.
There's a question of deferred payment also. Deferred payment of consideration.
I'll definitely.
So when you are arguing, please keep that in mind.
I'll definitely learn from. I'll examine money.
It's an academic discussion. Don't worry about it. I'm not giving a finding on your case immediately right now. So so simply that consideration was not paid. Here we are not on that. We are on a different concept. You say that consideration may have been paid, but it was paid to somebody else.
Yes.
Defendant number 6.
Yes.
But then, as learned senior counsel has pointed out, I don't know. I have to see the evidence. Defendant number 5. It is their case that defendant number 6 paid it to defendant number 5, and he admits that I have received the consideration. So he is the person to say whether he has received the consideration or not.
Your lordship may kindly see the written statement. They have admitted that it is not paid to the defendant number 5. Defendant number 6 received the amount.
True.
But if your lordship considers my prayer, my lord, I may be permitted once that to verify that judgment relied by my learned senior once at least.
No,
I'll examine, my lord. Time to examine.
Yeah, you can.
That section 90, 91 and 92, how far it is relevant to the present facts, my lord. I'm sorry.
The question is, अब आउ थोड़ा पढ़ो राजस्व आदायकारी को ठारे राजस्व इत्यादि करी मु भूलटा पढ़ली आद्य दिवस ठारे गला हां और आरंभ नामित थिबा तफसिल मुताबिक एते 80 डेसिमल जमी को शीर्षोक्त मूल्य 24,000 टंका जर्समन रे विक्रय करिया पे कथा स्थिर करी हला स्थिर करी एति टंका फाइनल हला जरसमन को समस्त टंका एथि पूर्वे आंभ बासगृह ठारे बुझी नै
The sole question is whether
एइथिरा आउ एविडेंस आपण दे परिबे
whether the I understood your lordship's mind, whether the defendant number 5 had any right to alienate the property.
That's a different matter. You are
that is the question to be decided by your lordship. No. And it cannot be transferred without the consent of the all the plaintiffs.
That is a complete then you are going tangent. First thing is whether oral evidence is admissible. In view of this clear that पढ़िले कोन बुझी होय ना बुझी
so far as oral evidence is concerned, I will examine.
Second part I am helping you again. You have to crystallize your arguments into 3 different channels. Don't jumble up. Don't mix it. This is one part.
Yes.
That we will take care.
Yes.
Second part is you say that he has no alienable right.
Yes.
That has to be examined. Third is he did not as a karta of the family, as he claims, he had no legal necessity to sell it. These are the 3 points.
Yes.
Basically. And somewhere I found somewhere down the line some fraud allegation has also been made.
Yes.
But there being no pleading for fraud, very difficult to sustain.
But plaintiffs reserve their right to file the suit because it's a property in a nature of ancestral one.
Okay.
So if your lordship considers my prayer, my lord, I may be permitted some time to examine that document and the judgment relied by my learned senior. So document actually mo pakhre.
So when do you work?
After 1 week, if your lordship considers me.
Sir, we'll take it up after 1 week. Third further arguments in part, place this matter on week commencing 5th August.
Obliged, deeply obliged. I beg apology if I have made any.
No, don't think.
It's always an opportunity for me to argue. And for my learned senior is there at the other end, it's always an opportunity for me.
For everybody.
I'm obliged to lose.
Item number 2.
Hey, don't talk about it. Item 2. Yes. Who's opposing you, Mr. Satpathy?
Opposing Mr.
Kenati.
No, you are there. Yes. I have no claim against these. His opposition only for assistance purpose.
All right.
Contesting opposition, but Mr. Ajananda, sir.
He is not there. After been also Anyway,
I beg your pardon, on behalf of Mr. G.N. One password.
No, password. Pattern matter, password after be say. All right, let him argue for some time. Yes. Yes, please.
The last occasion I have had my written note of argument. the suit filed by the plaintiff.
You had a short note of submissions.
Short note of submissions.
Yes.
That will be
Again, a confirming decree.
This is not a confirming decree, but my contention, my merits in the appeal has not been taken note of by, has not been considered on the plea of technicality of res judicata. What happened? Plaintiff filed suit with 3 prayers to declare sale deed void, to declare will void, and to declare right title interest over the possession of the land. Plaintiff's suit partly decreed and partly dismissed. So far as the declaration of sale deed void has been refused in respect of my friend's client, defendant number 2 and 5. So far as the declaration of right title interest has been made by declaring my will, the executed in my favor, is invalid will. Plaintiff filed 1 appeal before the first appellate court, challenging the sale deed is valid or the decree part of the decree. That appeal has been registered and that appeal decided in the year 2005. The subsequent appeal, just one number 242-43, I have filed appeal challenging the finding, declaring my will is invalid. My appeal decided in the year 2011. The appellant in the first appeal 42, the plaintiff
you have to go through that
again. Plaintiff suit is.
It was, I remember this time, this was very confusing on the last occasion also, because the schedules are different who have challenged and all that.
That
I
is,
remember.
You
are the defendant.
I am the defendant number 1. So now successor defendant number 1 is died. I am successor.
Yes.
The suit para 3 of my written note, my lord.
Yes.
I have quoted the prayer to declare the sale deed executed by Chandravati Majhi to defendant number 2, 3, 4 and 5 as void and not binding on the plaintiff to cancel the sale. To declare the registered will executed by the Chandravati Majhi in favor of Parameswar Majhi, defendant number 1, as illegal, void, not binding on the plaintiff. To recover possession of the suit land from the defendants, and the same may be given by delivery of possession to the plaintiff through court. Now, next page, I have quoted the schedule A, B, C, D, E, F. A is the total property 18 acre. B is a sale deed which declared as void. C is the sale deed which declared valid. D, schedule property, which is part of the 18 acre division. The sale deed declared void. E, the part of the property, sale deed declared as valid. That is in favor of Mr. Both's client. So C property, schedule land and E schedule land. F schedule land is the subject matter of will. That is my challenge before the first appellate court, which declared will is declared void. As I have not able to establish the will has been executed without free from suspicion and the genuineness is in doubt by as per the observation of the trial court. There is the genealogy to consider. Bimbadhar is the common ancestor. According to the plaintiff, Bimbadhar has 2 sons, Mara and Jatia. But according to the defendant, Bimbadhar had 3 sons, Bhuja, Mara and Jatia. The Mara had son Kondu and Janagi is the daughter. And Jatia saw her son Gangadhar who died issueless. Therefore, the Jatia property came to the share branch of Mara according to the plaintiff. And since Kondu and Chandravati has no issue, that property came to Janaki and the Mandara and Lakshmana are the plaintiffs claim.
The other branch has been ignored, that Bhuja.
Bhuja branch has been ignored. We have technically that Bhuja is the branch son of a Bimbadhara, and we have produced the settlement record at the inquiry. But as I have not examined that before the trial court disbelieved my status. You have produced the document, but author of the document has not been examined and accepted me as not a legal heir of Bimbadhara. And so far my for the trial court that Chandravati has executed a will in favor of Parameswar, the defendant number 1. and that will is executed, registered will. The attesting witness examined, scribe has been examined, but the trial court disbelieved the.
Suspicious circumstances
Na suspicious circumstances কিন্তু কয় যে what is the occasion to make the will?
সেই তো
So that is the finding.
এটা আগে satisfied নহলে খালি আপনার 68 এভিডেন্স অ্যাক্ট 68 অনুসারে ওজন attesting witness को नहीं इसमें scribe को नहीं इसलिए ही जो
না
नहीं मुझे জানি আগে
না হবে না but the
as district judge of a particular place on a prime location 5 acres of land there was a will. I had rejected it because fully suspicious circumstance and the beneficiary himself was one of the signatories.
But the
so you can never say that.
Available documents.
He has no grievance against me. I'll just ask.
Oh, you want to go? Yes, please. Yes.
So my friend is there. I'll come.
Yes.
Let him come.
Yes.
But available material I will produce.
No, I'm not saying of this case. But what you said that only because
complaints is not sufficient. Mere exemption. But the
court has to have a subjective satisfaction that it is free from all suspicion and yes.
Therefore the plaintiff preferred the appeal.
And this Chandravati issue a Pardhanashini lady?
No, my lord.
No. Educated lady.
Educated lady, and that will is my lord.
Then that 63 Supreme Court will come into play.
Again.
Korbuja queer. Anyway, Mr. Sadmati, please continue.
Chandravati
Tipoti.
Tippo means the Pardhanashini lady.
Yeah, Tippo means Pardhanashini already. But we take them to be
same standard.
Yes.
Standard border of proof and standard of proof same.
63 Supreme Court basing that on that Privy Council.
Again.
Yes.
That thereafter my second para 11.
Para 11.
Para 11. I prepared the table, my lord.
Yes.
In this case, the plaintiff filed RFA number 42 of 2005. I have my file RFA number 43 of 2005, which is renumbered by out of transfer. Plaintiff's appeal was exact only to challenge the declaration of sale deed under Schedule C and E property as valid, except nothing. No other grounds, no other controversy raised in that appeal. My subject matter of challenge in my appeal to declare that will, the declaration made by the court below will as not genuine is the subject matter of challenge. And my status, Bhuja is not the son of Bimbadhar, is the subject matter challenge in my appeal. But inadvertently, either from the side latches of the lawyer or the parties' communication gap, both the appeal could not club together. Plaintiff's appeal decided in the year 2005 on 28/11/2005. And that in that appeal, entire argument advanced by the plaintiff appellant with regard to the validity of the sale deed and objection raised by the concerned respondent with regard to the correctness.
Yes, I remember last time also we were discussing that both the appeals should have been clubbed together, and that is precisely why it should have been clubbed to avoid conflicting orders being passed.
My submission, my lord. Therefore, the controversy between two appeals are different, and prayer made in two appeals in all together are different.
I asked you to find out judgments. Did you find?
My lord. On this issue, so the judgment of the world of 1923.
But it doesn't matter. Principle whether res judicata.
Allahabad High Court in a 5 judges made judgment.
Whether res judicata would apply in this case.
That is that. The Allahabad High Court that has been referred in the 77 Supreme Court, my lord. Para 8 of that.
Para 8.
Para 8. That is this is a suit where the plaintiff filed a mortgage suit claiming interest and to challenge enforcement of mortgage. The suit was decreed, but so far as the interest was set aside, not allowed. Plaintiff challenged the part of the decree where the interest has not been allowed, and defendant also challenged the decree in two appeals. In two appeals that has been allowed. Thereafter, question came before the second appeal. One appeal plaintiff's suit which has been allowed and appeal has been allowed. That appeal has not been challenged. Question of res judicata has been raised. The preliminary objection has been raised. The second non-filing of the second appeal against that judgment, the present appeal is not maintained. That has been referred to the 5 judges bench.
Let us see, para 8.
An objection has been taken for hearing on this appeal on the ground that the appellant has not appealed from the decision by lower appellate court of connected appeal, but both of which are decided by the same judgment. The circumstances under which the objection arises are these. The plaintiff appellant brought a suit for sale on a mortgage. The defendant contested suit on the ground, among others, and the amount of interest claimed as excessive. The court of first instances overruled this plea and declared the claim of interest but disallowed the cost to the plaintiff, as the amount of interest had swelled to a larger figure. Both the parties appealed from this decree. The plaintiff on question of cost and the defendant on the question of interest. The defendant's appeal was number 459 and the plaintiff's appeal was number 460. Both the appeals were disposed of by the same judgment. The lower appellate court allowed both the appeals, reduced the amount of interest awarded by the first court, but allowed cost the plaintiff. The plaintiff's appeal number 460 was thus decided in his favor. He accepted the decision and did not appeal from it. As the other appeal number 459, which related to interest, was decided against him, he preferred the present appeal from decision appeal number 459. It was continued that as both the appeals were decided by the lower appellate court by the same judgment and a plaintiff has not appealed from the decision in appeal number 460, the present appeal is not maintainable. Like this situation. In support of this contention, the full bench case of Jahira versus Debiya so has been relied upon. In my judgment, that case has no bearing on the present case and objection on behalf of the respondent is not tenable. The question before us whether the plaintiff is precluded from maintaining the present appeal by reason of which allowing this is the decision in the connected appeal to become final. And we are not called upon to decide whether ruling in the case of Jahira versus Debiya that so.
The case last mentioned.
Again.
In my judgment, we say to Aram.
Again.
In my judgment. That dilen tole.
In my judgment, where the same question or issue arises between the same parties or between the persons, though, through whom they claim in two suits or two appeals, the party against whom the question or issue is decided is bound to appeal from the decision in both the suits or appeals. And if allows the decision in one suit or appeals are to stand on reverse and to become final, he is precluded from maintaining the appeal preferred by him from the decision in one of the suits or appeals only. Where an issue has been decided between the same parties or their predecessor in a title in two suits or appeal, the decision if on reverse is binding on the parties. If the party to whose prejudice the question has been decided allow the judgment in one of the cases to become final, therefore binding on him, the court cannot in other cases appeal to go behind the decision which has become final, and the necessary result is that appeal in which same question is sought to be reopened cannot be sustained. This is what that is the Jahira cases finding. This is what has held in case of Jahira. In this case, this is the in that case, two rival suits for preemption in respect of the same cell were brought by two claimants, each of whom asserted as against the other that he had paramount of title to preempt. The claim of one of the two rival plaintiffs was decreed. The defeated plaintiff appealed from the decision in one of the suits, and the judgment and decree in other suit thus become final as between the parties. It was held that as the same issue had been raised in tried in both the suits and the decision of it one should become final as between the parties, it is operate as res judicata. The issue could not be reopened and trial in the appeal preferred by the party against whom the issue had been decided. I fully agree with the decision and find nothing in the judgment Stanley Justice, who delivered the main judgment in this case, from which one may dissent. This case does not in this case does not in any way support the contention of the respondent. The ruling Damodar Das was not relied upon by the learned advocate for the appellant, and we are not called upon to pronounce any opinion to the correctness of or otherwise of the decision in that case. If it become deemed to have been laid down any rule of law inconsistent with the decision of Jaira, I am not prepared to follow it. I have no reason stated in the judgment for overruling the objection taken in that case. If the learned judges intended to hold that no plea of res judicata could merely because one judgment was delivered in two cases, as held by the Calcutta High Court in one case cited in the judgment, I am unable with great respect to agree with them. In the present case, the only question which was decided in the appeal preferred to the court below by the plaintiff, appeal number 460, was the question of cost, and that was decided in the plaintiff's favor. He had therefore no occasion to appeal against the decision in that case, and his omission to appeal from that decision does not bar his present appeal. That is my submission, madam. Since I have no way affected by the judgment of past in the plaintiff's appeal, I have no necessity to challenge the same. And that issue controversy purely foreign to me, because the plaintiff clubbed all the prayers in respect of all the defendants by one. That's why the confusion created whether that appeal is order is applicable as a res judicata or not. The full bench therefore observed, therefore no occasion to appeal against the decision in that case, and his omission to appeal from that is a highlighted. Omission to appeal from that decision does not bar his present appeal. No issue was decided in appeal number 460 which was adverse to him, and no issue which arose as decided in that appeal arises in the appeal now before us.
All right. I get your point. All right.
There is therefore no bar for to the hearing.
All right, Mr. Sir. The point is taken.
Since except that plea of res judicata attaining the judgment finality, no other finding in the appellate court judgment. I am placing that appellate court.
Place
Again.
So as I was pointing out on the last occasion, maybe Mr. Bose is not that we can adjourn it to some other date. But what will happen now? It has to be remanded.
Remanded.
Because these facts cannot be gone into by the second appellate court, obviously.
Only since the court confused himself as the one part of the judgment has been confirmed, the other part cannot be reopened. That's why my matter may be remanded. The merits of the
okay, we will grant one more opportunity. I could have closed it today, but all right, heard further arguments in part. Let's this matter next week.
Okay.
Hello. In a week commencing 29th.
Item number 3.
Mr. Tripathi is held up in court number 24, man. So my learned senior may argue the case. I will take note
Yes,
of it.
yes. Yes, Mr. Doctor.
The defendants are in appeal, challenging a reversing judgment.
Yes.
Plaintiff filed suit for declaration of right title interest, confirmation of possession, in alternate recovery of possession, permanent injunction, and this but I'd like to show my lords that plaint and prayer. If your lordship have I'll share with my lords. Only that prayer I'll read.
Just a moment, what is the substantial question of law framed?
But the question of law framed as it is on record, but it's not the question of law to be determined. I have given the additional question.
Yeah, that's all right. That's all right. I just wanted to know what was framed.
It's not the case borne out.
Whether the plea of title as well as
possession and purchase wrongs in court. That's not the case of the defendant.
we can always frame an additional
Yes,
point.
but that I have suggested also.
Yes.
Yeah. Second point.
এটা খালি ଟିକେ ଆଗରୁ ଲେଖି ଦିଅନ୍ତୁ Learned counsel for the appellant submits a memorandum containing additional substantial questions of law. The same be kept on record. Yes, after conclusion of hearing, I'll.
Yes, Your Lordship will consider that. Lord, prayer as it appears.
Oh, you wanted me to see the LCR? Okay.
LCR is there.
Yes. LCR account.
Kindly see the plaint, para 14.
I will see it only if I find it.
Sir?
I'll see it if I can find it. Let me see.
I have a copy I can show.
No, finding in this scanned I mean page is very, very difficult.
Yes, so hard copy nahi LCR.
I'll फिर देखिए चेष्टा करो. हाँ, अच्छा. Paragraph 11.
Para 14. See the documentary land upon prayer lecture. Para 13, para 14.
That the plaintiff pays for the following reliefs.
Yes.
Right title, interest of the plaintiff.
Right, kindly see. Right title and interest of the plaintiff over Schedule A land may kindly be declared. Possession of the plaintiff be confirmed. In the alternative, recovery of possession from the defendants 1 and 2. Defendants be permanently injuncted not to change the status quo of the case land, not to alienate the case land, mandatory injunction and cost and other answer. So what is the case of the plaintiff here? Plaintiff is primarily basing upon a case of landlord and tenancy right. What the plaintiff says is, in the Sabak settlement, it was recorded in the name of two persons. Then those two persons alienated the property in favor of one Brajavasi Bedbag. That Brajavasi Bedbag has alienated part of that property, 10,000 square feet, in favor of two persons. One is that Mishra. Brajavasi Bedbag has purchased 4,000, Mitravanu has purchased 6,000. That is how, no, just original owners are Dhanu and Kalu. They are the original owners. Dhanu and Kalu sold 10,000 square feet to Brajavasi and Mitravanu. Brajavasi purchases 6,000, Mitravanu purchases 4,000. Then Brajavasi, out of his 6,000 square feet, sells away 4,000 in favor of one Dibakar Mishra. Now, Dibakar Mishra's legal heirs, the plaintiff's case is that Dibakar Mishra's legal heirs, by virtue of Exhibit 6 in the year 2002, executed a registered deed of sale in favor of the plaintiff. The case of the plaintiffs in the as delineated in the plaint itself is that Brajavasi has constructed a house there. Brajavasi inducted these defendants as tenants. They were paying rent. Consequent upon Brajavasi, after this Brajavasi sold the land to the plaintiffs, they became the landowner. Then they allowed these persons to remain in possession. Since they did not vacate the land, the suit with the prayer as aforesaid has been filed. This is the sum and substance of the plaintiff's case. Now, the defendant's case is that their mother had purchased adjoining land from Brajavasi. Prior to the defendant plaintiff purchased the land. They have constructed the house. While constructing their house, this part of the suit property also they started possessing by constructing their house over the land. The suit land which is claimed by the plaintiff, they being the adjacent landowners, they also constructed the land over the suit property. So they claimed relief of adverse possession in their written statement. Correct? Now the trial court, upon analysis of the rival claims of the parties and issues framed thereon, dismissed the plaintiff's suit with precise finding that the plaintiff's sale deed and description of property as it is appearing there is a Meladiho. That's the admitted document. There is no house there.
I've seen that.
That's it.
Last time she had sold.
Exhibit 8, there is a reference that the Anganwadi, Gharachi. So that is.
There's a discrepancy.
Exhibit 8 prepared 4 months after the sale. Correct.
What is Exhibit 8?
Exhibit 8 is the ROR, mutation ROR. 4 months after the purchase, 4 months after the sale, Exhibit 6 was executed.
Yes, I remember. She was saying that 4 months, 4 months ভিতরে কি এটা বড় করতে করে দেব। এই সেল ডিড এলা উপরে লেখা আছে মেলাডিও means the house
That means vacant homestead land.
Vacant homestead.
Vacant homestead land.
Not a fallow land.
Not a fallow land. Now,
that is the question she raised yesterday, last time. The 4 months ভিতরে কোন লোকটা কোন ঘর করে দেই পারিব? করি পারিব না, মই জানি। মাসেকরে ঘর হই যাଉଛି 4 মাসের ওভার কোন অসুবিধা হচ্ছে?
না না সেতে ঘর করিবা না করিবার কথা নাই। Question হচ্ছে the equal lordship sees what is the issue here. Trial court dismissed the suit equal lordship sees saying that the plaintiff has failed to prove possession in the sense precisely on the point that the sale deed was not backed by delivery of possession. The reason being, the admitted case of the plaintiff being the defendants were in possession, may be permissive possession. Prior to execution of plaintiff sale deed 2002, that is what the admitted case is. If your lordship sees the plaintiff, kindly see, since 97, the admitted position, though we have remained in position much prior to that, but the admission is since 97 in the evidence they have said somewhere.
Let us accept it.
Right. So the sale is not backed by delivery of possession. That is one of the reasons given by the trial court. Second, this sale deed which was executed with respect to a Meladia, now the plaint is filed for the house. The admitted position is that they have said before the court that we executed the sale deed to defraud the stamp duty for the purpose of avoiding registration. Now a deed without payment of stamp duty. What is the procedure available for the court below to be dealt with? That is one more question which the trial court has dealt with and has disbelieved the plaintiff's case.
No, okay. Oh. Yes. I think there's a provision for payment of stamp duty along with penalty.
Impound hobo na age.
Impound hoyi tapor hobo kon?
Age to impound hobo, otherwise it becomes inadmissible.
Collateral purpose mein hi paribo.
Collateral purpose.
Section 49, I think there's an amendment. It is Section 49 of the Registration Act. Read with that Odisha Indian Stamp Act. I've dealt with similar matter in one of my judgments recently. Though the contention was different.
Stamp Act
it can be used for collateral purposes.
Collateral purpose but then particular
the question is that provision probably 35 of the Stamp Act 35 probably.
35.
So that is relating to admissibility of the document.
Yes.
Here you are on the entirely different thing. Yes. You are saying that it is totally invalid.
Yes.
That is your case, as I gather.
Yes.
All right.
But kindly see the trial court's finding on that effect, on that score.
Trial court judgment.
Okay.
Yes. Page
14.
Internal page 14. All right. Contradictory statement.
Okay. 1 second. Kindly see page 13.
Yes.
In my copy, it is page 13.
Yes.
According to plaintiff, he purchased the suit land from sons of Dibakar. Sir,
according to the plaintiff, he purchased the suit land from the sons of Dibakar
Mishra, namely Somanath Vishwanath, one Bannojan, son of Somanath Mishra, on the strength of registered sale deed for a consideration of 68,000 and took delivery of possession on this of the same on this same very day. It is also in it that since then he is in possession over the suit land, and para 7 of his plaint, he claims to have mutated the suit land in his name and received mutation ROR from concerned Tahsildar for the same. But subsequently in para 9 of the plaintiff appears to have taken the contrary stand as to delivery of possession of the suit land soon after the sale thereof in his favor by his vendors. Because the shared para, he has changed his said stand by mentioning that during lifetime of Divakar Mishra, without knowing the facts as to the house over the suit land to be let out in favor of defendant 1 and 2 in the year 1997. This is what I was saying. 97. The plaintiff, at the request of the said defendants, allowed them to remain in the house on rent basis at the rate of rupees 500 per month, with understanding that they will leave the house after getting suitable accommodation. During the course of his evidence PW1, plaintiff has almost taken the self-same stand in conformity with that of plaintiff governments as to his purchase of the suit land as well as alleged permissive possession of the house over the suit land in favor of defendant 1 and 2. However, in para 9 of his evidence, he has made contradictory statement from that of the plaintiff governments to the effect that after execution of sale deed by sons of Divakar Mishra, plaintiff at the request of defendants 1 and 2 allowed them to remain in the house on the basis rent basis 500 per month. So, from the aforesaid evidence PW1 himself, it is quite apparent that alleged sale of the suit land in his favor is not coupled with delivery possession thereof in his favor by his vendors. At this stage, it is submitted on behalf of the defendant that the sale deed in question appears to be nominal one, since the plaintiff did not have financial capacity to purchase the suit land at a consideration of 68,000 in the relevant year. In this regard, a reference has been made to the document Exhibit 1, proved on behalf of the plaintiff. On perusal of the said document, the same appears to be an income certificate issued in favor of plaintiff by Tahsildar Balangir on 11/3/2003, showing his annual income as 12,000. Further, on going through the cross-examination PW1 at para 14, it reveals that he was earning rupees 30 per day from his betel shop. 3 to 5 years, he was earning rupees 20 to 22 daily from his shop, and from the year 2002, he was earning about rupees 30 to 35 daily. It appears from that he is having his family with wife and children, and his income is not sufficient to maintain his family. In this last sentence of the said para, he admits to have no source of income except from his betel shop. From the aforesaid oral evidence PW1 read with income certificate Exhibit 1 granted in his favor by the competent authorities, clearly appears that on around the year 2002 and 3, he was having annual income of 12,000, whereas he claims to have purchased the suit by registered sale deed Exhibit 6 for a valuable consideration of 68,000. There is explanation either in the plaint or during his evidence as to from which source.
No explanation does it say. There is no explanation.
There is no hava katha.
There is source ta katha se.
Sir, refers to his evidence. The payment of such huge consideration amount by him during alleged purchase of the suit land has to be not believable. As such, the stand taken by defendant that sale deed Exhibit 6 is as a nominal appears to have been
not believable.
Appears to have been motive dekhi hone.
Appears from the
appears to be to have authentic na kon.
From the key position.
Apno pakhre sinte chi. Further, on going through the sale deed under Exhibit 3, it appears from the middle portion of the recital thereof at page 4 that at the time of purchase of the suit land, plaintiff, it was a meladiho, which was saying melod, and sale deed relates to 2002 by categorically mentioning therein to have no residential house there over at the time of purchase. Whereas from mutation hour, the said year issued in favor of plaintiff, it appears column number 9 thereof that the residential house existed over the suit plot. Thus, such description of mutation hour under Exhibit 8 in favor of plaintiff as to existence of residential house over the suit land very much falsified the stand as to purchase of vacant suit land from his vendor under Exhibit 6 on 16/8/2002. There is also no oral evidence laid on behalf of the plaintiff that he has with the question which your lordship was raising. There is no evidence that he has constructed the house in between land within 3 to 4 months after purchase thereof from his vendors before mutation of the suit land in his favor. On the other hand, the aforesaid document on Exhibit 8 strengthens the stand of the defendants about their construction of house over the purchased land, including that of the suit land.
So how does this
that is now all these points which has been dealt with by the trial court trial court, let me just point it out also, trial court also passed in judgment upholding the adverse possession in favor of the defendant over one. Appellate court, what the appellate court did is, appellate court only has dealt with the issue of adverse possession. Rest of the issues are ignored. The Lordship must be knowing, Santosh Vajari, the duty of the appellate court is to answer every issue, because that is the last fact-finding court. Lower appellate court duty, Santosh Vajari, 2001 Supreme Court. It is the duty, bounden duty to answer pass the judgment on all the issues involved in this case. Now, if Lordship see the appellate court judgment, save and accept adverse possession issue by shifting the burden to the defendants and dismissing, declaring the suit, he has not dealt with any other aspect of the case. Saying that this is the only vital issue to be considered, no other issues are vital. That your Lordship may kindly see.
So we'll continue tomorrow.
As your Lordship.
Continue tomorrow. Mr. Tripathi is not there. Other matters are there. I'll have to take.
As your Lordship.
I
prefer the day after tomorrow. He has difficulty tomorrow. He requested me the day after tomorrow.
24 all in the colors 24th कल लिख दिया हाँ और
Okay.
Item number 4.
Item 4.
No, 4, my lord. And we have filed a miscase for allowing us to fence the fruit land, my lord.
That miscase was filed in the year 2004.
My lord.
We are precisely 20 years later. So obviously, when you did not press the miscase for the last 20 years, it means you are not interested in it. Why should I take it up now? Appeal ready हो तो सारी बात.
My lord.
Miscase dismissed.
My lord, 3 weeks पर
3 weeks पर है.
मतलब ठीक है समय आसिए
ये आसिया कहता आसिया 2004 में से मतलब
2 weeks after 2 weeks.
Miscase. What is the other miscase? 570. Any order has been passed there? 3912.
My lord, is miscase number?
There is no other miscase.
No other miscase.
No, there is a miscase 570 of 2003. This is 671 of 2004.
Yes.
Which I was referring to. This case is you 671 of 2004. Is an application filed taking permission for refencing of the suit land during pendency of the appeal. The application was filed as far back as on 10/12/2004.
My lord, dispute of as because it was ordered to maintain status quo, my lord. That's why we have seek permission to refence the file as they were interruption by the other person.
Situation call. What is the situation now? Status quo order was passed.
My lord.
That is why obviously you came to the court in 2004 seeking permission to refence.
My lord.
Now 20 years have passed by in the meantime. Bada padila nahi. Tale?
My lord, ask.
Asio kon? Sita kaya kayo na?
Let the miscase be disposed of.
Yes. Disposed of and dismissed.
My lord.
Nahi. You're sugarcoating your words. That is good. Good advocacy. But it not impressed. As on 10/12/2004. Such application was filed on the ground that in view of the order of status quo passed by this court on 18/6/2004, leave of the court was necessary to refence the land. The application has been pending for the last 20 years, for the last nearly 20 years, without any motion being made by the petitioner for hearing of the same. Since the appeal is otherwise ready for hearing and an order of status quo exists, I find no reason to entertain the application so as to pass any further order with regard to the suit lab at this stage. The application is therefore rejected. The parties are directed to come ready for final disposal of the for final hearing. Yes, fix a date. Code date. Who's opposing you? Mr. Das, you are
State is there. State is there along with another private party.
My father was appearing, my late father was appearing for the respondent number 4, but I have not got the proper instruction, but I will take in the meantime.
Usually it is said my senior was appearing. The relation is never said in the court. All right.
I'm sorry.
So, it doesn't matter. Sorry. ଟିକେ ବୟସରେ ଆପଣଙ୍କୁ ବଡ ବୋଲି ଭାବୁଛି କିଛି ଜାଣିଛି ବୋଲି କହିଦେଲେ ଆଉ ସରି ଫରି କାହିଁ କହିବେ you are an officer of the court. I am also learning every day. When senior counsels are arguing, I am learning. Why senior counsel? I am learning from you also. କେବେ କୁହନ୍ତୁ ଡେଟ୍ କୁହନ୍ତୁ କୋଉ ଡେଟରେ ସେଦିନ ଆଉ ନୋ ଆଡଜର୍ନମେଣ୍ଟ
2 weeks after.
2 weeks ପରେ 2 weeks ପରେ ଗୋଟେ ଡେଟ୍
We commencing 12th August.
Please this matter in the week commencing 12th August under for hearing. Yes.
Item number 5.
Obligation.
Item 5. Item 5 is yours.
I am appearing for the respondent, my lord.
Who's for the appellant? Substitution.
On behalf of Mr. Ekenamber. Appellant.
Substitution not taken. Kebe molani kon halani?
Appellant is a very pretty old man, aged about 85 years. He is unable to move about that. Time may kindly be.
So 1 week time was allowed as last chance to take steps. You have not taken steps. No. The appeal will be dismissed. Here मर जाइए.
My lord, 2 and 7. 2 and 7, man.
It abates as against 2 and 7 upon.
As your lordship.
Despite the last chance being granted, no steps have been taken to substitute the deceased respondent numbers 2 and 7. Today, learned counsel for the appellant seeks further time. Stop. I am not inclined to grant any further time. The appeal stands dismissed as against respondent numbers 2 and
7, my
7. Get ready for hearing. There is this matter.
12th August. We commencing 12th August. We commencing 20th August.
20th August. Yes.
Item number 6.
Item 6, your lordship had directed me the other day to file an application for condoning the delay in filing the court fee. If your lordship permits, I can file the hard copy of the.
Please.
IA.
Because then it has to be again, SR has to be done probably.
IA रे SR
नहीं IA पे नहीं delay टा calculate करिए आप केबे फाइल करले
ये इधर 18/7 18/7 रे ready है so I am filing.
No, appeal was filed in.
Appeal was filed sometime in 2016
without the court fees.
The 149 application was filed.
149 was filed.
Yes.
Oh, it was permitted.
Yes.
Time was granted.
Yes.
Oh, yes. But time was granted 4 weeks. That was in 2016. And thereafter it was listed 8 years later, that is in 2024. So will issue notice? Yes, there. Hard copy, huh? Learned AGA, the IA available. Learned AGA files hard copy of the. This is the only copy. There is no e-filed copy also. This is the only copy. Files IA in court.
It has to be registered.
It will be registered. I will pass that on for condonation of delay in filing of the court fees. Actually, the total period will be, I think, will be treated as delayed.
Yes, has to.
Isn't it? It has to be treated as
the filing of.
So, IA be registered. Will issue notice? Issue notice to the respondent by speed post, fixing a short returnable date. The requisites be filed by day after tomorrow peremptorily.
Yes.
Peremptory.
Sir.
Peremptorily. Place this matter on at IA.
Yes.
Okay.
Commencing 9th September.
In the week commencing 9th September.
Item number 7.
Then IA 421 of 24 my lord.
Just a
Publication of notice through Delhi local newspaper.
कौन है जी कौन है जी
Publication of notice through Delhi local.
नहीं कहीं notice कौन है fresh steps to be taken for issuance of notice or respondent 2, 4 and 9
4 and 9
by speed post. Did you not?
I have filed a miscase relating to that my lord.
What
There are 721 of 24 my lord.
Why did you not take notice by speed post?
There I have filed a miscase for
Yes, why? What is the reason?
My lord.
What is the reason?
They are avoiding through paper publication. Yes, ma'am. They are avoiding. They are residing there. They are avoiding to.
IA 721 of 2024. This is an application for substituted for effecting substituted service on respondent numbers
2, 4 and 9.
2, 4 and 9. Stop. Such application. This application has been 2, 4, 9, 2, 3, 4. अच्छा हो. नहीं अपन 2, 3, 4, 9 and 10 लिखे थे.
All others have.
अच्छा all others have. It is the application has been filed on the ground that the said respondents are deliberately avoiding to receive notice, and therefore notice be published in a local newspaper. Considering the grounds and the fact that the appeal is of the year 2017, this court is inclined to allow the application. You have to submit a draft?
Yes, sir. Draft notice.
Draft notice be submitted 1 week from now. Within 3 days. Draft notice ପାଇଁ କଣ ଆପଣଙ୍କୁ ପକ୍ଷ ସାଙ୍ଗରେ କଥାବାର୍ତ୍ତା କରିବାକୁ ପଡିବ? Draft notice be submitted for approval within a week, peremptorily.
Yes, ma'am.
After it is approved, then requisites you will file. The cost you will deposit upon.
Yes, yes.
Yes. Is this matter?
Interim order to continue.
Interim order to continue. Next week, that's your interim order to continue.
Item number 8.
May I plead your lordship, my lord, I have filed the IA for substitution, setting aside abatement and limitation. In respect of respondent number 10 and 7.
There is delay?
No, my lord, there is a delay for filing of.
कितने दिन delay? Where is that delay टा कितने? IA कितने?
My lord, delay is 2 years.
नहीं IA टा कितने? को number टा कितने?
IA number 1550.
1550.
The period of delay I have not mentioned, particular period of delay.
This is an application for condonation of delay in filing the petition for substitution of respondent number 17.
10 and 17.
10 and 17 तो लिखना था अपन 17 केवल लिखिए. हाँ respond 10 and 17. It is stated that a junior counsel had prepared the substitution petition, but could not file it because of work pressure. Subsequently, it was the office remained under the impression that that substitution is not necessary. However, on further consultation with the advocate, it was given out that the deceased respondents required to be substituted by their LRs, since the right to sue survives. Considering the fact that the appellant has an arguable case
and the right to sue survives as against the LRs of the deceased respondents, I am inclined to take a lenient view. The delay in filing of the substitution petition is hereby condoned. তারপরে আরো দুইটা মিশিয়ে কি করিবে? This is an application for substitution of respondent number 10 and 17 who have died. By their, it is submitted that respondent number 10 died on 20/12/2021, leaving behind his widow, 2 daughters and a son. Respondent number 7 died on 18/6/2020, leaving behind his son, leaving behind only a daughter. The right to sue survives as against them. In such view of the matter, allow for the setting aside abatement and wallet. Consolidated cost right will be filed. So so be substituted as respondent numbers 10A, 17(1). Consolidated cost right will be filed within 3 working days. Is this matter? We'll have to issue notice to them. We'll have to issue notice to them who nobody is appearing for them.
No, my lord, the said second appeal is not till admitted.
Not yet been admitted.
No.
Is this matter on
September?
नहीं ये तो आरो वीक को मैंने ये जो अगस्त को डेट क्या?
The week commencing 12th August.
The week commencing 12th August for admission.
Item 9.
Case appeal notice was issued to respondent 4.
You are appearing.
I am for the respondent number 1. And I had undertaken to appear on behalf of respondent number 10 and 11.
Yes.
I am filing the Bhaklatnama today.
My lord, kindly pardon me, my lord. I am also appearing for respondent 2, 3, 4, 5 and 6.
Completed.
Completed then.
My,
Sir, your good name?
my name is Pramod Kumar Mishra.
Sri Pramod Kumar Mishra has entered appearance for respondent numbers
My lord, 2, 3, 4, 5 and 6.
2, 3, 4, 5 and 6. He files Vakalatnama in the court, same be kept on record. His name be reflected in the cause list.
I am filing my lord the Bhaklatnama in registry.
Registry. You have filed or you will file?
No, I am filing.
Sri Achan Mahapatra undertakes to appear for respondent number
10 and 11.
10 and 11 by filing Vakalatnama
Today, my lord.
today in the office.
Right.
His name be also reflected in the cost title. So this has been admitted and everything is done. So we are ready.
Yes.
2018 मसीहा matter जाओ September रे दिखे.
My lord, I have filed one application for early hearing. Your lordship, since long. It was hard, in fact. It was hard by.
If you are ready, we can hear it any day. If you are ready, we can hear it.
Next week, my lord, or 1 week after.
What is the substantial question of law? Why today ଶୁଣିବା କଣ ଅଛି? LCR ଅଛି ତ? Let us see whether the LCR is there or not. LCR ଅଛି?
Here, my lord, I am for the appellant.
No, but LCR is not there. LCR will be necessary. We will call for the LCR after immediately after receipt of LCR we can.
No, date may be fixed. Otherwise, my lord, it will not be.
Best of.
Your lordship may kindly see for a moment. Just for a moment, my lord, for your
No.
kind appreciation of your lordship.
No, ମୁଁ ଦେଖିବି ନାହିଁ। LCR ତ ଆସିବ ଆଗୁତରା କାହିଁ ଦେଖିବି?
Then why want to actually apply to your lordship? Actually, what is the locus standi of the appellant?
Right.
Your lordship may kindly just for a moment.
I am just asking you one question. Can it be disposed of without the LCR? Then I am ready to hear.
But it was hard. It was argued and it was hard.
If it is necessary, then all right. We'll take it up tomorrow.
I am for the appellant.
Yes, I am asking you.
Yes. Get the LCR we call for because the confirming judgment.
LCR sanction email ରେ ଆସିବ.
Again.
LCR ଗୋଟେ week ରେ ଆସିବ.
LCR we call for next week.
Where is that order? Who order ହେଇଥିଲା LCR call
Your
for?
lordship may kindly see the judgment of the trial court.
Call for LCR call for 2019.
17/7/19.
ଆସିଥିବ ନିହାତି।
ଆସିଥିଲେ ସେ ସ୍କାନିଂ ରହିଯାଇଥାନ୍ତା ନା ଆସିନି ମୁଁ ଦେଖୁଛି ଅଫିସ ନୋଟ ଦେଖୁଛି ନା ଆଇ ଏମ୍ ଲୁକିଂ ଆଟ୍ ଦି ଅଫିସ ନୋଟ
ବେଳେବେଳେ ଅଫିସରେ ରହିଯାଏ ହୁଏନି ରଖିଥିବେ ଯଦି
ରିମାଇଣ୍ଡ ଦି କୋର୍ଟ ବିଲୋ ଟୁ transmit the LCR without any further delay if necessary through a special messenger so as to reach this court. କେବେ ଗୋଟେ ଡେଟ୍ କଲ?
29th July
ନାଇଁ 5th August କର
5th August list करला है so as to reach this court by 2nd of August. Release this case in the week commencing 5th of August. Hearing करो. नहीं 8th of. Under the heading orders.
Interim order is there.
Interim order to continue. कितना अच्छी हमारा
On previous date, it was not continued. Orders may continue.
आज ही तो है कौन? Yes.
I don't know 10.
Reproduction lordship. My lord, this is the first time that this case is listed before lordship. This second appeal is filed against the erroneous findings of the lower courts below. My lord,
Mr. Naik, the matter was listed before the registrar or the deputy registrar rather on 22/8/2019. Defects were pointed out. You have not removed the defects. Tell me one good reason why I should keep it pending any further.
my lord,
Probably, Mr. Naik, you are not interested to remove the defects.
no, lord. It is not that I beg permission from your lordship that at least 3 days may be allowed.
All right, 3 days. I'll allow you 1 week. List this matter next week. Sri A.K. Naik, learned counsel for the appellant, undertakes to remove the defects in the meantime. Yes. Nole, jahabo.
Item 11.
No, 11. Either 10 orders nale, kali baki to orders naba. Admission neji baki. So that at least we can touch admission matters. Sir, you are waiting for which matter?
Sir, item 33.
33 may not reach today, dekhiye.
My matter is a small matter. Item 21 for order.
Tomorrow definitely it will reach. Tomorrow it will reach.
So can I beg leave?
Yes, please. Yes, please. This list is for the entire week.
My lord.
So
That end.
my method is to at least touch everything. Aji 10 orders only, kali baki to 10
Again.
admission kichhi naba.
I have some problem. I will be absent for the next day, tomorrow and the day after tomorrow. So may I item 21 only for a condemnation of delay of 5 days. Can it be taken up?
Notice jibo kon.
Yes, ma'am.
Amu kon kordi peri condemnation.
Only 5 days delay.
Item 21.
21, my lord.
आइए रे issue notice.
598 of 2024.
There is only one respondent.
Only one.
Issue notice to the sole respondent by registered post with AD, returnable within 4 weeks, requisites be filed within 3 working days. Place this matter on.
I will comment in 9th September.
9th September.
Okay.
Yes.
Item number 22.
22, my lord. I am for the appellant, my lord. I'll take up tomorrow, my lord.
Pass over. Pass over for the day.
22. Arrest number 349. I am appearing for some respondents, but I have no copy of appeal memo. Maybe directed to.
This is admission.
Appeal is not added.
Yes, just one.
Appeal is not.
This is order 41, rule 11.
Order applies.
So, admit ho. Yes. You have so much appeared through caveat or?
नहीं so much
तो admission देखियो admission देख लो करो item 23
Item 23.
23
Logically, Passover can grant a Passover for
why
23.
why don't you try
Lordship, I've not gone through the matter. Lordship.
What? You have not gone through the brief, you are holding that brief. Anyway, all right, pass over. 24.
Item 24. Orders take tomorrow.
Admission touch kariyo. What is your matter?
Exemption of fee.
Item kya?
Item 15.
Why exemption? Were you exempted in the court below?
Filed an application, Lord, he is a physically disabled person.
Were you exempted in the appellate stage?
No, Lord, he was defendant, respondent in the court.
Okay.
I filed an application for disablement.
Where is the certificate?
I have filed this certificate.
So let the state verify. कौन करिया ये वेरीफाई करी कहबे कली यस मिस्टर दास आइए आइए रे Land State Council shall take instructions. Let a copy of the IA be served upon Land State Council, who shall take instructions with regard to the disability certificate appended thereto. List this matter. What a short date? 2 weeks later.
Mention 12th August.
12th August. Then I'll exempt it.
Let item 17.
नहीं आओ नहीं आया अपन कोर्ट रे थिले मु कर दिसन
आगे
एवं सब तो कोर्ट रे अपेक्षा करथिले बोली योर एसोसिएट वाज देयर इन द कोर्ट
आगे मोर खाली गोटे स्मॉल ये
कोन
स्पैंडर नंबर 1 मरि जाय ता एलआरस ऑलरेडी ऑन रिकॉर्ड
okay there is also limitation will issue notice also on that
and limitation your lordship already issued notice they have appeared
my lord
but item 17 is your matter.
Yes,
I am appearing on behalf of.
Just a moment. Now I think item 16 is referring to.
Item 16, Millard. I am sorry. I am 16.
Who died?
Let the respondent number 1 died.
Okay.
But her the legal
His LRs are already on record.
Already on record, Millard.
It is stated that it is submitted that respondent number 1 died.
2 and 3 are the LRs.
No. Died, leaving behind his LRs, who are already on record in the form of respondent numbers 2 and 3.
Yes, ma'am.
Yeah.
So far as the,
No substitution is necessary.
so far as the condonation of delay is concerned, Millard, 1 month, 10 days delay. And he was suffering for spinal.
Here for?
No, I am item 17.
So anybody appearing?
Somebody was.
तो काली पास आउट तो काली देखिए
Notice.
notice जाइए ना
Already got.
like somebody has appeared. Who is appearing? Mr.
Dayanand Mahapatra.
Dayananda Mahapatra. Where is he? He is not there. If you can inform him tomorrow,
Yes, yes. Yes, Millard.
Pass over. कौन defect remove ही नहीं.
No, 18-19 रे ये my lord the appellants were not made party in the appeal. They have not been substituted. That case, my lord. The IA is filed for the leave of the court.
Yes.
If that will be allowed, the appeal will be heard, my lord. Your lordship last occasion has directed to take notice on the respondent number, the brother and the mother of the appellants, my lord. I have filed the requisites for us it has been made sufficient. None has appeared. They have also filed 2 appeals, my lord. Your lordship has already admitted and have granted interim order in that appeal.
Here notice was issued. Anybody appearing?
Let
us see what has happened to the notice. AD back from respondent 1, 2, 39 and 40 after valid service. Yes. Office note indicates that service of notice on respondent numbers 1, 2, 39 and 40 is sufficient. I think I'll have to rise. There's a mishap. Yes. So there is, however, no appearance from their side. Stop. Hence, the IA is taken up for hearing. It is submitted that the petitioners of this application were not impleaded as parties before the first appellate court. They, however, they being the daughters of the deceased respondent, have the right to sue, and therefore they ought to have been substituted. Considering the above, the IA is allowed. Respondent number so and so are permitted to appeal, to file appeal.
And then the appeal will be had along with RSA 437, 438.
List this appeal along with RSA numbers.
They do. 19টা भी same order.
Item 17 condolation of delay, my lordship. 130 days delay. I have filed on IA 1032.
So notice I am appearing on the behalf of the respondent number 1, your lordship.
Other respondents?
Sure.
Notice has gone.
Yes, your lord.
Let us see.
Lordship, count.
Just. 2 and 3 received after personal service and held to be sufficient. आइए कितने दिन delay?
130 days.
Lordship, may I please, your lordship. Lordship, they have taken the ground that she is arranging money and she is a poor person. But your lordship, as per instruction, your lordship, she is in charge of headmistress of Saraswati Shishu Vidya Mandir School.
इसे cost कर दो cost कर दो.
My lordship, the Saraswati Shishu Vidya Mandir, my lordship, it's the appeal matter, second appeal, and the court fees are, everything is there, my lordship. So that may be considered while arranging money is a matter in the second appeal, my lordship.
100 कितने days delay you will pay cost होगा.
130 days.
नहीं cost तो क्या मना करते हैं cost दे. IA 31032 of 2023. This is an application for condonation of delay in filing of the appeal. Office has pointed out delay of 142 days. We will accept 142. It is submitted that it is stated that 1032. Stated that after considering the grounds cited in the application and upon hearing learned counsel for the appellant as also the respondent, the number 1, I am inclined to take a lenient view. The delay in filing of the appeal is hereby condoned, subject to payment of cost of rupees 1,000, which shall be paid to learned counsel for the respondent number 1 within a week, and receipt be filed before the court.
Yes, lordship, they have not provided the petition copy.
Admission नहीं ना, admission होगा, admission साला पर आप लोगों को कथा पूछा है. List this matter for admission. I have to rise. So, problem.